अरे अरे, हेलो हेलो, 1 2 3, हेलो हेलो। सही है। अरे थोड़ा लेट आएगी। हेलो 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 हेलो। जो बोल दिया उसको करना चाहिए। हेलो 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 हेलो। बहुत लेट है ना। से बोलेंगे तभी सुनाई देगा। हेलो हेलो हेलो। दे रहा। थोड़ा लेट आएगा ना।
Hello, 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 talk, hello, hello.
हेलो 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 हेलो।
Greetings of the day, Your Honor. The Council appearing on behalf of the... Yes, sir. Greetings of the day, Your Honor. The Council appearing on behalf of the appellant in the case of Galaxy Gaming Private Limited versus Union of Indiana. With the kind permission of the Honorable Bench, I shall proceed with my submissions. Much obliged, Your Honor. Your Honor, I, Counsel 1, shall be dealing with first and second contention, and my learned co-counsel shall be dealing with third, fourth, and fifth contention, and we'll be taking 21 minutes respectively of the bench time. Much obliged, Your Honor. Your Honor, the Council seeks permission to state the facts of the pertinent case. Much obliged, Your Honor. Your Honor, the Republic of Indiana promoted digital innovation, which rapidly led to... Your Honor, the Council seeks permission to state the facts of the pertinent case. Much obliged, Your Honor. Your Honor, the Republic of Indiana promoted digital innovation, which rapidly led to the innovation of online gaming sector. Furthermore, to address inconsistent and fragmented state regulations on games of skill, Parliament enacted OGRA 2025, which stands for Online Gaming Regulation Act. And Your Honors, under this act, a centralized authority was created, that is OGA, which stands for Online Gaming Authority. Though the act did not clearly distinguish the criteria for defining games of skills from games of chance, and before this law was enacted, Galaxy Gaming Private Limited launched Astra Play on 5th April 2025, and which was claimed to be a game based on skill. However, OGA classified Astra Play as a game of chance on 12th November 2025 and directed the company to shut down their operations within the next 72 hours on the ground that they are based on games of chance. Your Honor, around the same time, a data breach report of around 3 lakh users was reported and led to the proceedings under IT Act 2000 and DPDP Act 2023. For which the company denied the liability for, claiming it as external cyber attack. Additionally, an independent developers filed a complaint before the Competition Commission of Indiana, alleging restrictive clauses are there in the company's framework. To summarize the facts, Your Honor, due to constitutional challenges to OGRA 2025, and broader legal issues that are involved in the pertinent matter, the matter was ultimately referred by Delhi High Court to the Supreme Court of Indiana for judicial review. If Your Honors are satisfied with the facts of the case, the Council seeks permission to proceed with the jurisdiction. Much obliged, Your Honor. Your Honor, the Council has approached the Supreme Court of Indiana under Article 139A of the Constitution of Indiana. With this, the Council shall now proceed with the contentions. Much obliged, Your Honor. Coming to the first contention, that whether the indiscriminate prohibition on real money gaming under OGRA 2025, including games of skill, is legally sustainable or arbitrary and disproportionate. Your Honor, for the ease of understanding this issue wholeheartedly, the Council have further divided it into 3 sub-contentions. So moving further with sub-contention 1.1, that is, OGRA 2025 is manifestly arbitrary and fails the test of reasonable classification. It is most humbly submitted before the Honorable Court that the impugned provisions of OGRA 2025, hereinafter referred to as Online Gaming Regulation Act, suffer from grave constitutional infirmities, Your Honor, while the objective of the legislation, namely consumer protection, digital governance, and prevention of gambling-related harm, as clearly mentioned in paragraph 11 of the Moot proposition, if Your Honors may refer to it, Your Honor, it is completely illegitimate as the means adopted in its implementation is excessive and arbitrary. Moving further, Your Honor, it is also in direct violation of Section 8, Subclause 2 of the Auger Act 2025. If Your Honors may refer to the bare provisions of the Act. Much obliged, Your Honor. Your Honor, at the very outset, it is submitted that reasonable classification is something which is the cornerstone of Article 14 jurisprudence. And Your Honor, any law that differentiates between classes of person or activities must satisfy the twin tests of intelligible differentia and rational nexus as held in a very landmark case of State of West Bengal versus Anwar Ali Sarkar. If Your Honors may kindly refer to flag number 1 of the compendium. If Your Honors are with me. Flag number 1, Your Honor, and paragraph number 3. Flag number 1, paragraph 3. It's on page number 2 of the compendium. Your Honor, the counsel is referring to the compendium and not to the arguments advanced. No, the flagging is also done. The flag numbers are also there. Your Honor, in the compendium, flagging is done. Only one copy of the compendium have been submitted. Much obliged. All right. All right, sir. So, Your Honor, connecting this case to the present matter. Indeed, Your Honor, intelligible differentia, it means that there must be a connection, and also, moreover, the kind of a rational nexus and the object behind how. Indeed not, Your Honor. There is not a connection in the pertinent matter, Your Honor, that the petitioner is contending. Indeed, Your Honor. Indeed, Your Honor, the counsel would like to reaffirm the fact that petitioner is contending OGRA 2025 is manifestly arbitrary and does not have a rational nexus that the counsel will be further elucidating, if Your Honors may know. Indeed, Your Honor. Your Honor, connecting the case to the present matter, whereby OGRA 2025 fails at the very first threshold, as the Act fails to codify any criteria to distinguish between games of chance and games of skill, as explicitly given in third line of para 11 of the Moot proposition itself, and nor it establish any rational nexus with the consumer's protection, because even the safe and skill-based platforms are being restricted without giving any proper justification. Your Honor, as well recognized by Justice D.Y. Chandrachud in a landmark case of Indra Sodi versus Union of India, that the counsel has noted it.
Do you think that by referring to a judge's name, the judgment adds more weight to the law or something?
Indeed not, Your Honor. The counsel seeks pardon for this and will take care of it next time.
One principle, it's become very fashionable nowadays.
Indeed, Your Honor.
Like in American courts.
Indeed.
These are Indian courts. We are not personality-based courts.
Indeed, Your Honor.
Understand?
Yes.
The law is what the law says.
Indeed.
Judgment says, not what the judge says.
Indeed, Your Honor.
The judge speaks for the entire court. Even a single bench speaks for the entire court.
Indeed, Your Honor. The counsel completely agree with the fact and
Very
will.
fashionable now.
Indeed, Your Honor.
Just say honorable court.
Indeed, sir. So, the Honorable Court held that an action of state which is arbitrary, irrational or disproportionate violates the constitutional guarantee of equality, fairness and cannot be sustained. Moreover, Your Honor, the determination of an activity, whether it constitutes as a game of skill or game of chance, is not merely administrative in nature, but it directly impacts the fundamental rights under Article 14 and under Article 19, Clause 1, Subclause G of the Constitution of Indiana. Your Honor, this not only create legal uncertainty for the petitioner, but for the entire gaming sector, because the respondent has painted all the industries with the same brush, and at the end of the day, Your Honor, operators cannot predict how their games are going to be classified as games of class and games of skill, on what basis they are going to be distinguished. Moving further, Your Honor, with subcontention 1.2, that OGRA 2025 is vitiated.
Do you have the classification order?
Pardon, Your Honor?
Is classification order part of the compendium?
Regarding the games of skills and games of chance. Your Honor, the council have mentioned a landmark case which distinguish between the games of chance and games of...
Classification that your petitioner's company's game is a game of chance and not game of skill.
Indeed not, Your Honor. The petitioner is claiming that their game is based on games of skill and not on the games of chance.
I'm on a different issue. The authority says that it's a game of chance,
Indeed,
not
Your
game
Honor.
of skill.
Indeed, Your Honor.
There's a classification order. Can I have the classification order? Is there part of compendium?
Indeed not, Your Honor, but there is not a particular definition which have been codified in the statute. Indeed, Your Honor.
You have said that an order has been passed saying this is a game of chance. Is there any such order anywhere? That's all. Either a yes or a no.
Indeed not, Your Honor, but several judicial procedures are there. So proceeding further with subcontention 1.2, that OGRA 2025 is vitiated by excessive delegation. As observed in R.N. Chadi and Brothers versus Subhash Chandra, that justice hurried may amount to justice buried. Your Honor, in the present case, this principle squarely applies, as OGRA 2025 has hastily transferred the unguided and excessive discretionary power to OGA in its entirety. The ancillary functions can be delegated, but Your Honor, the core legislative functions cannot be directly given to the OGA. Your Honor, the determination of what constitutes a game of skill or chance is core legislative function and is directly affecting the fundamental rights as well as...
Have you heard of something called subordinate legislation?
Indeed, Your Honor.
Then?
Your Honor, but the council would like to emphasize on the fact that it is humbly submitted that the delegation of ancillary functions can be done, and that too on the some standards, principles and guidelines, but in the pertinent matter, Your Honor, OGRA 2025 delegates this critical function entirely to OGA without prescribing any guidelines, which definitely led to the excessive power. And Your Honor, it is to be noted here that OGA is acting as investigator, regulator and adjudicator simultaneously, which not only violates the principles of separations of power, but also the principles of nemo judex and causa sua, whereby in the pertinent case, OGA conducted the audit. They classified Astra play as a game of chance, and they also denied the representation of the petitioners, if Your Honors may refer to para 20 of the Moot proposition, without giving a opportunity of being heard. That directly violates the principles of audio ultram partem coming under natural justice. And lastly, Your Honors, the same authority is acting as judge, jury and executioner. Your Honor, at the end of the day, such high concentration of power enshrined in one authority will definitely lead to abuse of power and arbitrariness. Moving further, Your Honor, with subcontention 1.3, that OGRA 2025 imposes disproportionate and unreasonable restriction. Your Honor, in E.P. Royappa versus State of Tamil Nadu, the court expanded the ambit of Article 14 and doctrine of necessity, and it was held that the least restrictive measures such as age gating, spending limits and regulatory oversight must be implemented, as also mentioned in para 15 of the Moot proposition itself. Therefore, the respondent has overstepped the thin line difference between regulation and prohibition. With this, the council seeks permission to proceed further with issue number 2. Much obliged, Your Honor. Issue number 2, it deals with whether Parliament possesses legislative competence to enact OGRA 2025 or whether the Act amounts to impermissible encroachment upon state autonomy or federal structure. Moving further with subcontention 2.1, that Parliament lacks legislative competence to enact OGRA 2025. It is most humbly submitted that the foremost and first test to determine the legislative competence of anything is the doctrine of pith and substance, Your Honor, which requires the Honorable Court to ascertain the true nature and character of the impugned legislation in the pertinent matter. The court must look beyond the apparent structure of OGRA 2025 and must examine its dominant purpose, object, and its effect. Your Honor, the true character of OGRA 2025 as evident from the Moot proposition itself, paragraph 9, 10 and 11, lies in its attempt to create or control platforms offering real money games, impose restrictions based on monetary stakes, and specifically gambling related harm should be curbed. Your Honor, the council would like to draw your attention on the above stated elements. These all elements are classic elements of gambling, Your Honors. And therefore, the respondent has erred in the interpretation of the legislative entries concerning betting and gambling, which is explicitly enumerated under list 2, entry number 34 of schedule 7 of the Constitution of Indiana. Your Honor, moving further, the maxim substance over form must be applied in the pertinent matter, Your Honor, where the legislative entries must not be bypassed through indirect methods. The respondent's attempt to classify gambling as digital service is merely a constitutional camouflage as enshrined under Article 246 subclause 3 of Constitution of Indiana. State enjoy exclusive authority over matters enumerated in list 2, and this exclusivity, Your Honors, must not be diluted by mere union entries, as the legal maxim generalist, specialist, non-derogant exists, that general laws do not override the special laws, and so is the case in the pertinent matter, Your Honor. With this, the council shall proceed with subcontention 2.2, that OGRA 2025 does not prevail as the subject matter falls directly within entries 34 and 62 of the state list. It is humbly submitted that Article 254 applies only in situations where both the Parliament and state can make laws, specifically in the concurrent list, Your Honors. This judgment is particularly significant as it directly addresses the digital context and reinforces the medium, whether it is online or offline. It does not change the real nature of the games of skill, Your Honors. Proceeding further, the council would like to cite the most authoritative report of Sarkaria Commission 1988, if Your Honors may refer to it. Page number 2, paragraph 3rd, which have regarding the center and state relationships, and they have emphasized on the fact that balance in federal structure must be maintained, as also the same thing was reaffirmed in 2 landmark judgments of Keshav Nand Bharti versus State of Kerala, whereby the court held that federalism is the basic structure of the constitution and it must not be disturbed, as it will be in violation of Article 246 subclause 3 of the Constitution of Indiana.
Small question.
Indeed, Your Honor.
We are dealing with the digital age.
Indeed, Your Honor.
State A legislates for a game. Now that game is going to go all over the country.
Indeed, Your Honor.
So State B legislates to the contrary. State C comes out with a third solution, fourth, fifth, sixth. So how will this end? We are in the digital age, remember.
Indeed, Your
this
Honor.
is not that there are going to be games within Haryana or games within so and so. You are regulating.
Indeed, Your Honor.
How will you answer that?
Indeed, Your Honor, the council completely agreed with the fact that we all are growing up in a digital era, but this cannot be taken as a defense to impose such regulation which is completely invalid, unconstitutional.
My question to you is not that whether this is ultra wideys or not.
Indeed, Your Honor.
Question is a digital app, let's put it, an app. It's eventually it's an app. All
Indeed.
games are apps in
Indeed.
some way or the other. Is available, if I get it registered in Punjab, it's available to me in Tamil Nadu.
Indeed, Your Honor.
So won't the person in Tamil Nadu say my rights have been violated? Because why is this Punjab app coming here?
Indeed, Your Honor.
So that means there can't be a legislation at all. If we accept your argument,
Indeed.
then it is to be in list 2.
Indeed, Your Honor, the Council would like to again reaffirm the same thing, that in the Moot proposition itself on paragraph 5, 6 and 7,
There
it
is a
is
slight
mentioned.
ambiguity in the Moot proposition itself.
Indeed, Your Honor.
The Moot proposition does not take care of this.
Indeed, Your Honor.
Of digital world. It's treating a digital proposition like a normal, statute.
Indeed, Your Honor. The
So
Council.
I think a small advice to the people.
Indeed, Your Honor, but the state regulations were already into existence and union.
That's what I'm saying. There'll be suppose there's a conflict between the state regulation, two
Indeed,
state
Your Honor.
regulations, which will prevail?
Your Honor, the Council would like to again refer to the Moot proposition, because we are also obliged to go by the Moot proposition. So I would like to say that the state regulations were already into existence, and that too they were prohibiting certain gaming platforms which were operating without the license and compliance requirements. And Your Honor, what union has tried to do in the particular case, they have artificially tried to create an overlap in the defense that they are protecting the consumers.
Is there any provision in the Constitution where two state governments enact contrary laws regarding the same subject matter which traverses borders?
Indeed,
Then
Your
what
Honor.
happens? Any provision of that?
Indeed, Your Honor, it is regarding the repugnant laws, and it is given under 249 or 250. 254, Your Honor, it is given under Article 254 of the Constitution of India.
Read it, repugnancy between?
Inconsistency between laws made by Parliament and laws made by legislature
Here we don't
states.
have a parliament legislature, no?
We do have.
That's-
But then what happens? Inconsistency. Read it.
Indeed, Your Honor, if any provision of law made by the legislature of state is repugnant to any provision of law made by Parliament, which Parliament is competent to enact, or any provision of the existing law with respect to any matters enumerated in the concurrent list, then the subject of the provision of subclause 2, the law made by the Parliament, whether passed before or after the law made by the legislature of such state as the case may be, existing law shall prevail, and the law made by the legislature of the state shall, to the extent repugnant, be void. But Your Honours, the Council would like to completely disagree with the fact, because in
Then
the
first of all,
pertinent
you'll have
matter.
First, you have to disagree with the state law. You have to challenge the state law being arbitrary. And then
Indeed
comes
not,
the
Your Honour. State laws are not at all arbitrary. The Council is challenging the Unified Act that was created, which was OGRA
What is the
2025.
difference between the state law and the central law?
Indeed, Your Honour.
We are giving you 2 minutes more.
Much obliged, Your Honour. Your Honour, the Council would like to differentiate state laws and OGRA 2025, which was a unified law, on the basis of first thing, that is the subject matter. The subject matter that state law was dealing with, that was the regulation of online gaming. Whereas the OGRA 2025, which was a union law, it was dealing particularly with gambling related harms, which is again given in the Moot proposition itself, para number 11, third line, that they were trying to prevent or curb the activities related with gambling. And Your Honour, directly it is given in the 7th schedule, list 2, entry 34, that gambling and betting related things are enumerated in state list and cannot be bypassed by the union entries.
Health also.
Indeed, Your Honour, because on
The health on game line, on online gaming.
Uh,
There's no such entry.
Your Honour, certain things which, there are certain exceptions to it, obviously. For example, if something is in favor of public interest, or large public interest is harmed, for example in the case of health only, then Parliament can legislate on such matters. But connecting again to the present Moot proposition, nothing of this sort is there, Your Honours. Therefore, the OGRA 2025 must be struck down, and it is unconstitutional. It was indeed a pleasure arguing before the bench. Now my co-counsel shall be dealing with 3rd, 4th and 5th contention. Much obliged, Your Honour.
Please.
Can I begin? May it please the court, the counsel too shall be dealing with contention 3, 4 and 5. Before beginning, Your Honours, I shall be referring to the issues in turn. Your Honours, the very first issue is whether Galaxy Gaming is liable for the alleged data breach. The second is whether minors collection, data collection of minors is statutorily aligned or not, and the third is whether the creator access framework of Galaxy Gaming is anti-competitive in nature. Your Honours, before beginning, I would like to give a brief of the facts of this case so that it's better for the court to understand. Your Honours, it is to be noted over here that on October 30, consumer concerns escalated. Your Honours, 2025, October 30, 2025, Your Honours, consumer concerns escalated after a report of data breach involving Astra Play came out, Your Honours. This report told that personal and financial data of the users were circulated on dark web, Your Honours. Your Honours, beginning with my argument, it is to be humbly submitted that the respondents have not produced any server log correlation, that is the data breach and Astra Play. Also, Your Honours, there is no forensic attribution that these data breaches are associated with Astra Play. Because, Your Honours, these report... Your Honours, I am coming to that fact. Your Honours, the report of data breach, they are sourceless, Your Honours, first thing, which is not admissible in the court as per the case of Anwar PV Bakshi versus PK Bashir, Your Honours. Your Honours, the digital forensic report must be given under section 65B of the Evidence Act, which is now section 63A of the BSA. Your Honours, further regarding the question regarding the data breach. Your Honours, if we look at para 22, it suggests that the preliminary investigation suggested that there has been a vulnerability in Astra Play, but it is a vulnerability in the analytical dashboard, Your Honours. Your Honours, I'll be little technical about it, that in today's modern digital architecture, it operates through functional segments, and an analytical dashboard has nothing to do with financial and personal data of the users, Your Honour. It is a visualization layer, Your Honour. So, Your Honours, as there is no causation chain between the said data breach and the vulnerability in Astra Play, therefore the very first stage, the attribution fails in this case, Your Honours. Even assuming, Your Honours, that there has been a vulnerability in Astra Play, the council would contend that section 43A, Your Honours, it explicitly says that the body corporate must implement reasonable security practices, Your Honours. Your Honours, through reasonable security practices, the legislation is trying to invoke that there must be reasonable standard. It should be not it is not about absoluteness or infallible security, it is about the reasonable security standard and industry maintains, Your Honours. In the present matter, as it is already mentioned in the Moot prop, I would like to tell on para 16, Your Honours, it says that Galaxy Gaming had voluntarily adopted responsible gaming measures. Also, Your Honours, they had self-exclusion mechanism, Your Honours. This clearly shows that they were compliant with the reasonable security practices, and the reasonable security practices, Your Honours, it is given in Rule 6 of DPDP Act, which clearly says that it must follow the ISO IEC 2700 methodology, Your Honours, and the company was following it. Therefore, Your Honours, as it is already said in the case of Jacob Matthew versus State of Punjab, Your Honours, though it is a medical negligence case, but Your Honours, it is to be noted that reasonable care and negligence, whether in any industry, this is the standard operation, Your Honours, that reasonable care must be taken, and in this case, Your Honours, the court clarified that liability arises only where there is a breach of reasonable standard of care and not merely because the harm occurred, Your Honours. Therefore, the implementation of reasonable security practice is itself a parameter that they should be not held liable under section 43A of the IT Act, Your Honours. Your Honours, further moving to the very main contention of the petitioners, Your Honours, is that the mens rea under section 72A, Your Honours, that is absent in the present matter. Your Honours, section 72A says that there must be directing mind and will of the corporation when there is a data breach, Your Honors. It is also held in Indrum India Telecom versus Motorola Incorporated. Your Honor, in the present matter, Galaxy Gaming is nowhere directly involved in the data breach. No employee is there, Your Honors. There is no evidence that Galaxy Gaming sold the user's data, did transfer it, or they have monetized it. So basically, Your Honors, the core of section 72 A, that is mens rea, that is also absent in pertaining case, and that's why, Your Honors, the petitioner would contend that taking the account of section 43A and 72A is legally unsustainable for the petitioners.
The November 12, 25 audit and the classification issue, it
Yes,
said
sir.
it extrapolated to be a game of chance. It is you have been asked to wind up within 72 hours because you are a game of chance and not a game of skill.
I would like to differ on this point, Your Honors, that on November 12, OGA declared us a game of chance. I agree with this fact, but this has nothing to do with data breach, Your Honors.
That's a separate issue.
Yes,
but
Your
you
Honors.
are also a violator of this because you are a game of chance.
Your Honors, but taking this in account, if we look at the other side of the picture, the OGA, as already mentioned by my co-counsel, they have extensive power, Your Honor, they are arbitrary in nature. Furthermore, Your Honors, we could take in this in the other angle as well, that OGA, first they classified us game of chance, then they told us to halt our real money operation, and then how come, Your Honors, till 6 months it is given in the Moot prop that there was no criminal, just a second, Your Honor, there was no criminal liability upon us. Out of nowhere, a sourceless report comes up. It is very evident, Your Honors, that in a digital world, information flows like wildfire, Your Honors, and false information flows even more higher. We have not notified that we are suffering from any breach because we have our system. If any breach would have occurred, we would have known. Still, Your Honors, we could have taken into other account that they are trying to take us in liability.
The question is simple, that they came to know that there was a data breach. You can't go into that question because that's nothing non-negotiable as a problem here. The point is that you are Astra Play is a game of chance. You have been asked to discontinue because you're a game of chance. The data breach is another issue.
Yes,
just
Your
because
Honors.
they discovered that there was a data breach, they checked on you and they found that you're Astra Play's game of chance.
Yes, Your
Therefore, they
Honors.
asked you to discontinue.
Your Honors, this is
What do you
little.
have to say about that?
Yes, Your Honors, I am coming to that point. Your Honors, the Moot prop is a little different in this point. Actually, we are representing Galaxy Gaming. Your Honors, we are, the Council 2 is representing only Galaxy Gaming, and my co-counsel was representing public interest organization. The Council 2 and Galaxy Gaming has nothing to do with OGRA, Your Honors. We are only and only to the...
Which public interest organization?
Your Honors, if we look at the para 29, Your Honors, public interest organization have
Actually,
filed petition.
Two petitioners have been
Yes,
mixed
Your
up.
Honors. Yes, Your Honors.
You
This
should have
is...
mentioned that in the beginning. Anyway, even you, question is for
Your Honors,
particularly you.
this is some what Your Honors are trying to explain. This is a fault in the Moot prop itself, that they are mixing two things simultaneously. We are just concerned to the data breach. We have, even if Your Honors, we are game of chance or game of skill or real money gaming, we have the data. It has nothing to do with that they told us to stop our operations. Data is there with us. So we are only concerned with the IT Act and DPDP. OGRA is something, Your Honors, which was concerned with public interest organization. So if you,
Date of OG order,
Your Honors, it is 12 November
12 November.
25.
You should always say the year of,
Sorry, Your Honors.
whenever you are in the court.
25, all are in 25.
OGA order is 12 November 2025.
Yes, Your
And
Honors.
when this data breach was found to be there,
Your Honors, it is October 30, 2025.
October 13.
30, 30, Your Honors.
On 30th of October 2025, there is no order that your game is a data of.
Yes, Your Honor, this is what I'm trying
So
to claim.
you are only
Galaxy Gaming, Your Honor.
only challenging.
That we
holding
are
you
not
liable
liable
for-
in DPDP and IT Act.
That's all. Your claim is, then you should have clarified right at the start.
Your Honor, in the very beginning I said that I am representing Galaxy
We
Gaming.
don't, see, we are not expected to read everything.
Yes, Your Honor, I agree to this point.
You're expected to tell us. That
Your
my
Honor,
case is
will keep
different
this in
from
mind.
of speaker one. Because you said there are 5 issues
Yes, Your Honor.
which the petitioners have raised.
Correct.
Your Honor,
and
the
therefore these are
cases.
two. This
Your Honor,
I
it
deal
was.
with two.
We thought you were all both the same, for the same party.
Your Honor, it is actually that the cases were being clubbed by the Supreme Court. So this is something that now it is being clarified that Council 2 is only and only representing Galaxy Gaming. It has nothing to do with Ogra, Your
So
Honor.
you have been asked to shut down.
Your
what
Honor,
ground?
again.
Because
Your
it's a
Honor,
game of
again it is on Ogra, and it is again the fact that they are claiming that we are real money gaming. That's why they are telling us to shut down.
Real gaming. What is real game? Money
That
gaming.
involves money in stake.
That involves, take it a little further, a
Uh,
game of chance.
Game of chance.
That's why you've been shut down.
Your Honor, I'm not contending why are we being shut down or not. I'm
You're
just
happy with being
contending.
shut down.
No, Your Honor, that is something that is not in our part. Your Honor,
course
I am.
Of course, that's your challenge.
The entire
No, Your
challenge
Honor,
is-
we are not. This is little getting confused over here, Your Honor. That
We are supposed to be confused. You are supposed to
yes,
clarify.
Your Honor, this is what I'm being clarifying.
What
that
is your main ground of challenge?
that Your
For what
Honor,
purpose
the
you are
data
being
breach, the alleged data breach is not related to
You
Astra
are
Play.
representing Galaxy.
Yes, Your Honor, but we are not contending related to.
I'm not challenging that you have been clubbed, you have been
Shut down.
Shut down.
Your Honor, that is not the
You
contention.
have been tagged as
They are not the shutdown
game of.
Your Honor, that is not the contention. The contention, Your Honor, that is, you can refer to the. Your Honor, you can refer to the issues given in the moot prop. The issue is only
Astra
related
Play
to
belongs
data.
you or not?
Sorry.
Astra Play.
Yes, Your Honor.
Then
That's
Astra
being
Play
shut
belongs to gaming.
Your Honor, this is what the council is trying to explain, that the contentions provided by the moot prop is only and
She is on issue 3 only, nothing beyond that.
no, Your Honor, this is not something like that. The contention is only related to data breach. The shutdown matter and everything, that is a separate entity altogether, and that is not what the council is arguing.
But why was the public interest person challenging the shutdown?
Your Honor, that is
I
again.
just wanted to ask. The public interest person was challenging
You are not
this
challenging the shutdown.
No, Your Honor, that
you
is.
You are also not challenging the shutdown
They are challenging the legality of OGRA.
of the act.
Yes, Your Honor, this is something which is provided in
So
the
what
moot
has
prop.
been shut down?
Your Honor, again.
Nobody is challenging the shutdown.
No, Your Honor, the contention are provided. Your Honor, the contention are provided by the memorial, by the memo, and that's why this is something we are just strictly adhering to it.
Therefore, please try and understand.
Yes, Your Honor.
It is the duty of people providing the memorial to make it confusing so that you as councils can clarify it.
Your Honor,
If
the
everything
council.
was straight,
I guess, Your Honor, the council are now, that the judges are now clear that the council is only and only challenging the data breach, which is on October 30th,
Let me read
2025.
the moot proposition for you.
Your Honor.
Come to para 8. Do you have the moot proposition?
Yes, Your Honor.
November 12, 25. Following a sector-wide audit, OGA issued a classification order declaring Astra Play to be a game of chance. The order relied upon internal algorithms so-and-so. It was asked to shut down. Para 9. Galaxy Gaming was direct to halt all real money operation within 72 hours, failing which there will be criminal prosecution against you. Galaxy Gaming filed a detailed representing challenging
was
the
rejected.
methodology of arguing that the audit was opaque and scientifically unsound. So you have challenged it.
Your Honor.
Yeah, you have challenged it. See the paradigm of the moot proposition itself. How
Your
can you
Honor.
say the moot proposition is incorrect?
Your Honor, the moot proposition is not incorrect, but if we look at issues for consideration, the very last, Your Honor, could you please refer after para 32 the issues for consideration before the Supreme Court, Your Honor?
Come to the moot proposition. Why
Yes,
do you go there?
Your Honor, just a second. I would,
Alright.
like to demonstrate
Alright,
one thing.
sure.
The issues are given by the moot preposition. The issues, if you just read the issues, Your Honor, it has nothing to do with the shutdown area. That's why, Your Honor, we are just contending what is given to us.
Shut down, no problem.
No, Your Honor, we are not happy, but that,
No objection, shut down.
Your Honor, we are not, right now there is no objection towards the shutdown. We are only objecting the data breach, Your Honor.
Okay, you are on contention 3.
3, yes, Your Honor. Your Honor,
Alright, you carry on now. Finish, forget it. No, carry on.
Data disclosure, they are only on data disclosure.
Whatever it is, you carry on.
We are lucky we don't have to pronounce the judgment.
Your Honor, it is a bit confusing. I agree with this.
Carry on.
No, they should have made separate.
Yes, Your Honor.
Okay, carry on, please.
Your Honors, if your Honors are satisfied with contention 3, the council will be moving to contention 4. Your Honors, this is a wide arena contention. Yes, Your Honors, whether the collection
Contention 3.
Held at their
is done, Your
Simple question.
Yes, Your
Do
Honors.
you agree there were data breach?
No, Your Honors.
There were no data breach at all?
No, Your Honors. The attribution which the respondents are saying that the data was related to us, the attribution is not there, Your Honors. They are saying that we have leaked the personal and financial data, but there is no compromise and
You said there is no mens rea.
yes, Your
You said there is no
Your
mens
Honors,
rea.
Your Honors, the
There were
council,
data breach, but there were no mens rea.
Your Honors, the council said that for the sake of argument, if we are assuming that there has been a data breach, for that sake, Your Honors, I was establishing that, but the attribution part has been already established that since there is no attribution, there is no case, but for the sake of argument, the council was interpreting that section 43A and 72A does not apply on Galaxy
Read
TV.
para 50,
15, Your Honors.
50.
Your Honors, para 50 of
Something we've got.
That's the problem. Nobody is referring to the page number and para number.
Para
Of,
50, page 13. Where you're talking about the data breach.
yes, Your Honors.
Read it. Your case is
Memorial.
there. Your entire case is there.
Yes,
Here.
Your Honors.
If you don't have it, I pass on my copy.
Your Honors, actually, we have, just a second, Your Honors. Page number
13.
13.
They do- lawyers
Yes,
do
Your
that.
Honor.
Yes.
Yes, Your Honors. In this case, Your Honors, the compromised
Can you
analytical...
read para 50, please?
50.
50, yes, Your Honors. In the present matter, there is no evidence on record demonstrating the authenticity of data sheet in its integrity, its origination, extraction, or its forensic linkage to Astra Play server. The respondent has not produced any server log correlations, hash value verifications, IP trace mapping, metadata analysis or independent forensic audit conclusively establishing that alleged data sheet has originated from Astra Play.
This was a case, you should have argued this and said, okay, bye, I'm going home.
Your Honors, I have already said
You
that there
haven't
is
said
no
all
attribution.
this.
Your Honors,
We didn't hear it. Our fault.
You carry
No,
on in
not
any
it.
which way you want to carry on. Come on. Go.
Your Honors, the fourth contention in picture is a wide spectrum. It is not related to only Galaxy Gaming. It is a question in general given in the Moot prop that whether the collection and processing of behavioral data, particularly of minor, violates statutory obligation, Your Honors. Your Honors, it is to be noted over here. Your Honors, I beg type. Your Honors, it is to be noted over here that behavioral gaming data does not constitute as personal data to come under Data Protection Act, Your Honors. Your Honors, it is to be noted that section 2 clause T of DPDP Act defines what is personal data and identifiability. It is its core. Your Honors, it is to be noted that behavioral gaming data is something which is related to game matrix, session duration, response time and movement pattern, Your Honors. This has nothing to do with the identifiability of player. It has nothing to do with the ID or with the pertaining identifier, Your Honors. Therefore, Your Honors, at the very ground level, behavior gaming data does not constitute as personal data. Therefore, counting it under DPDP is itself a failure, Your Honors. Your Honors, moving to quickly to contention 5. Again, Your Honors, before moving to this, this is related to Competition Act. again, and this a small brief of facts, that it is said that Galaxy Gaming has a creator access framework which puts contractual obligation on its developer, which restricts them from deploying similar game module for 2 years, Your Honors. This is what is there, and Galaxy Gaming over here, we are contending that it is something which comes under IP and it is exempted under section 3 clause 5 of Competition Act, Your Honors. Your Honors, it is to be noted that the developers are saying that we are restricting them from entering into the market. But Your Honors, for this the dominance test must be proved, Your Honors, in the Competition Act, which is given in section 4, Your Honors. Your Honors, section 4 tells what is dominance. If we carefully look, the market share of Astra Play, Your Honors, it is only 0.4% of the market share. This established that there is no dominance at all of Astra Play in the market, and therefore the very core, that is the dominance for abuse of power, that is not being established, Your Honors. Further, Your Honors, the developers are not being restricted from multi-housing, they are not being restricted from innovation, Your Honors. We are just restricting them from making similar game module, because this directly comes under the Copyright Act, Your Honors. And as a module, Your Honors, in today's tech, the graphics are so high that it takes around 2 to 3 years and lot of finance to implement it. Therefore, the duration of 2 years restriction on similar game modules, Your Honors, it is applicable and justifiable, Your Honors. If Your Honors have any question to this, the council shall be pleased to answer them. Your Honors, the council is done with the submission. The council shall begin with its prayer. In the lights of the facts of the case, issues raised, arguments advanced and authorities cited, the council on behalf of the petitioners humbly pray before the Honorable Supreme Court of Indiana to kindly adjudge and declare that OGRA is legally unsustainable, arbitrary and disproportionate, declare that union has no legal authority to enact OGRA, declare that Astra Play is not liable under section 43A and 72A, and the framework, the creator access framework of Galaxy Gaming comes under Competition Act, Your Honors, and or pass any other judgment which the court deems fit in the best interest of justice, equity and good concise, and with this act of court, the council on behalf of the petitioner as in duty bound shall forever play, Your Honors. It was great arguing before the learned bench.
Thank you, we have lied. For your argument. If you look at there is no factual basis for anything. There is no factual basis for anything. There is legal points and then there is the factual this is a mistake. Even their arguments are not factual. We have to see this.
Yes, come, start.
Greetings to the honorable bench. The council seeks permission to address the bench collectively as your lordships. Much obliged, your lordship. The council appears on behalf of the respondents and will be dealing with issue 1 and 2, taking 20 minutes of the honorable court's time. My co-counsel will be dealing with issue 3, 4 and 5, will be taking 20 minutes of the honorable court's time. We have reserved 5 minutes for the rebuttal, your lordships. The council seeks, before moving on with the issues, your lordships, the council seeks permission to bring into the light a couple of contentions which were made by the petitioner.
You are appearing for whom?
We are appearing on behalf of the state, Your Honor.
State,
The respondents.
The Union of India. Okay.
Before moving on to the issue, the council would like to bring a couple of things to the lordship's attention. Firstly, the petitioner have challenged that there is no direct or rational nexus which was used by OGRA to classify the game based on skill or based on chance. However, this is incorrect, your lordship. If your lordships could refer to paragraph 11 of the Moot prop, it is the council would read it verbatim for your lordship's convenience. While the statement of objective and reasons already emphasize consumer protection, your lordship, so there is already a reasonable nexus which is already mentioned in the statement of objectives and reasons, your lordships.
This is petitioner.
us already. It's there with us already. So,
Yes, okay.
Much obliged, Your Lordships.
Respondent, we only one, where is the respondent? This one?
Please
Continue.
refer to the page number and para number.
Certainly, Your Lordships. Right now, the Council is referring to the Moot Prop, Your Lordship. Paragraph 11 of the Moot Prop, Your Lordship. The Council will also read it verbatim for Your Lordship's convenience. Certainly, Your Lordship. While in the statement of objects and reasons, it is already emphasized consumer protection, Your Lordship. The petitioner have contended that there is no rational nexus. However, in the statement of objective and reason, it is already stated consumer protection is their object and reason. Further on, the rational nexus is also established in paragraph 24 of the Moot Prop itself, Your Lordship. The Council would again read it verbatim. Digital ethics scholars and child rights organizations raised broader concerns regarding immersive gaming environments, algorithmic engagement loops, and heightened vulnerability of minors in real money gaming ecosystems. And this was the reason OGRA was enacted. So the rational nexus is well established, Your Lordships. Further on, they paint a picture that there was some prejudice against Galaxy Gaming Limited, Your Honor. They say their game was classified unreasonably. However, Your Lordship, this again is misguiding, since it is written in paragraph 17 of the Moot Prop, Your Lordships, that there was a sector-wise audit, Your Lordship. Only Galaxy Gaming was not at all, they were not pinpointed. That was not the only game which was audited, Your Lordship. It was a sector-wise audit, and their Galaxy Gaming was classified as a game of chance, Your Lordship. So there was no prejudice which was by the state when they were classifying the games, Your Lordship. Your Lordships, paragraph 17, the Council would read it verbatim for the bench's convenience. The number of companies, the specific number is not mentioned in the Moot Prop, Your Lordships. However, it is written, OGRA initiated sector-wise classification audits of prominent online gaming platforms, Your Lordships.
Could be a large number.
So there was a sector-wise audit, Your Lordship. No one company was pinpointed, Your Lordships. Now the Council would seek permission to move on with the issues, Your Lordships. Much obliged, Your Lordships.
So in your order, you have not said that Galaxy's this game is game of chance.
Your Lordships, it is mentioned.
That's why you wanted to see the order. Where's the order? Classification order.
Read para 19, read para 19.
Certainly, Your Lordship.
Para
It-
18.
Yes, Your Lordship. The Council would also bring Your Lordship's attention to paragraph 19, where it is clearly written that Galaxy Gaming was directed to halt all real money operations, Your Lordship. Their game as in totality was not banned. Only the real money operations which were present in the game were asked to be shut down within 72 hours.
the
So
small
we have...
question here, you said the nexus was to protect rights of children. Here you are shutting down the financials,
Your Lordships,
not the game as such. So if there was something seriously wrong with the game, it was impacting minors, then where's the question of this money being shut down and game being allowed?
Your Lordships, since Astra-Play is a real money online operation, Your Lordships, the minors' consumer protection is one of the issue. Furthermore, there was a data breach of over 3 lakh users.
You're right, but see, the proof of everything is in the pudding, na? In the eating it. So if they were violating any rights of minors, the entire game should have been shut down, na? Not just the financial. You said shut down only the financial part.
Real money operations, Your Honor. Your Honor, that was because the data which was collected by the company, the data which was collected, as the real money gaming brings the harm to over 3 lakh users, we had to ban, because that is also consumer protection, Honor. Minors are one part of a big bracket of consumers. So minors were harmed as well as there were...
We only reacted from what you said.
Certainly, Your Lordship.
We not said anything on our own. You said something, we reacted.
Certainly, Your Lordships.
You addressed the issues raised by the
Petitioners, yes, Your Lordship. Certainly, Your Lordship. The Council would again just re-emphasize that there was consumer protection in general, and minors are a part of consumer protection. So this was a twofold manner. So consumers in general were also harmed and minors were also harmed. So that is why real money operations, only real money operations were put down, your lordship. The game as a whole, there was a very narrow approach which was taken. They pinpointed the real issue and only that was addressed. The whole game was not shut down, your honor. So there was no prejudice of the state in this regard. Now moving on with the issues, your honor. It is most respectfully submitted that this provision of Online Gaming Regulation Act 2025 does not violate Article 14 of the Constitution, your honor. In the judgment of Union of India versus MP
Please,
Will.
I don't know why everybody is so obsessed with judgments. In every moot, first, where's the factual basis for that it does not violate Article 14? Where is that? Even they only citing judgments, no factual basis for anything.
Your lordships,
Everything goes on facts, then the law applies.
certainly your lordship. Here the council was just
What's
trying.
the factual basis for your argument that Article 14 is not violated?
Certainly, your lordship. Article 14 is not violated, your lordship, because there is a twin test for reasonability which is established by Supreme Court, your lordship. It says that there should be
Again,
firstly.
Supreme Court.
Sorry,
I'm
your
asking
lordship.
you for facts.
Your lordship, the
Supreme
council.
Court cannot supplement facts.
Certainly, your lordship. Here there lies an intelligible differentia and there is a direct nexus, as already argued by the council, that there is a direct nexus which is present, as also seen in the moot prop, your lordships, and arguing on the fact of intelligible differentia, your lordships. The act distinguishes real money online gaming from non-monetized gaming, your lordship. This is again written in paragraph 9 of the moot prop, your lordships. The council would read it verbatim for your lordship's convenience. The statute introduced a centralized licensing regime for online gaming platforms, empowering OGA to classify game as game of skill, chance or real money gaming, your lordship. So there is an intelligible differentia which the OGA is performing upon, your lordship. So there is an intelligible differentia, there is a rational nexus. The games which are banned, they...
Mr. Counsel, you were at point of Article 14.
Certainly, your lordship. Article 14...
Where are the facts for it?
Your lordship,
Coming back to
Your lordship, Article 14, they are contending that this act is arbitrary in nature. To prove that it is not arbitrary in nature, it must satisfy twin test of classification. First is intelligible differentia and rational nexus.
So what is the survey you carried out to establish that you've got data to show this question of intelligent differentia? It is always based on facts. When you say that a particular set of people constitute a particular set and the other constitutes another set, and therefore there is an intelligible differentia, correct? So you conduct a survey on that and then place it on that. Where is that?
Your lordship, there is an intelligible differentia because in paragraph 9, as the council has
We
stated,
find nothing intelligible, non-intelligent.
Your lordship, the OGA was supposed to classify the games based on chance, game of skill or real money game. Your honor, this itself provides that there is an intelligible differentia since there are brackets which are already made for games to be classified into.
Yeah.
This proves that there is an intelligible differentia. They are not putting games into one bracket however they please, your honor, because the brackets are already established and OGA is supposed to classify the games into these specific brackets, your lordship. So hence the council is contending there is an intelligible differentia. Furthermore, there is also a...
Just one question.
Certainly, your
What are those
lordship.
parameters on the basis of which the OGA can decide is a game of chance or game of skill?
Certainly, your lordship. In the current prop...
That is where the facts come in.
Certainly, your lordship. In the moot prop, it is written that the act also authorized, they delegated... sorry, your lordship. Again, paragraph 9 of the moot prop, your lordship.
Yes, please read it.
Certainly, your lordship. The act also authorized the delegation, authorized the...
Are you on para 9?
Yes, your lordship. The last line, your lordship.
You should say the last line.
Apologies.
You're reading the para and you read the last line, you should say that under the last line. Yes.
Apologies. Now, reading paragraph 10, first line, your lordship.
Read 9 first.
Certainly, your lordship, paragraph 10 would pinpoint the exact
9 it doesn't have.
paragraph 10.
9 doesn't have that. That's okay.
Okay, yes, please.
Reading the first line of paragraph 10, your lordship.
Read it out.
OGRA 2025 vested extensive regulatory power in OGA, including the authority to conduct algorithmic audits, age, mandate age verification protocols and prescribe responsible gaming obligation, require real money behavioral monitoring and impose civil as well as criminal liability for misclassification or non-compliance, Your Lordship. Here the authority is vested in OGA to classify the games.
Right, so what do you have to say about this, the state and center legislation?
Your Lordship, that is the issue 2, Your Lordships. The council still has further arguments for issue 1. So if the...
Carry on, carry on.
Certainly, Your Lordship. Moving on, so the council has established that there...
After para 10, there's a large number of paras dealing with what you're saying. Now, at the end of those paras, please tell us, where did you conduct this survey on the basis of audits, mandate, age verification, etc., so as to arrive at a reasonable opinion that they are violating the provisions of this and therefore they have to be prohibited?
Your Lordship, in paragraph 17 of the Moot prop, OGRA first line, Your Lordship, OGRA initiated sector-wise classification audits of prominent online gaming platform, Your Lordship. So there was power vested in OGA, Your Lordship, that they could conduct audits. Here in paragraph 17, they have used that power, they have conducted a sector-wise audit, and in that audit,
But
Galaxy
you are
Game...
saying they were not disclosed publicly, or they were not subjected to independent peer review. It means a blanket authority has been given to OGA, whatever they decide, that's final. Are you representing OGA also?
Your Lordships, we are... No, Your
You are not
Lordships.
representing OGA.
They represent the government, which is the OGA.
OGA, which government which have enacted OGA, Your Lordship.
So ultimately you are representing OGA.
Certainly, Your
So,
Lordship.
suppose, before you take this decision, should you not have told them, this is what we found against you? What do you have to say?
Your Lordships,
There's nothing like that in the OGA.
You simply say, close down your business, we are giving you 72 hours, that's all, because yours is a game of chance.
Your
As the
Lordships,
principles of natural justice was followed,
Your Lordship, they were given a chance to appeal, Your Lordship. The chance to appeal...
to appeal against the order, but before you pass the order, was any hearing was granted to them?
Audi Altrum.
Part, yeah. Certainly, Your Lordship. However, there are certain exceptions to fair hearing, Your Lordship. That is necessity and public welfare. In this case, here...
In today's time, business is the only,
Yes.
business has the only opportunity of hearing. Nobody else gets.
Your Lordship,
So therefore, they are a business. They are generating money for the government.
Your Lordship,
And they have been generating money for years together. What was the urgency that you were giving just 72 hours to close down the business without any opportunity of being heard?
Your Lordship, there was a data breach of 3 lakh users, which included personal data, financial data.
Is that the basis of closing down the business?
Your,
Is
Your-
that the basis of our game? It is a game of chance. That's the basis.
Your Lordship, I would kindly request Your Lordship to refer to paragraph 18 of the Moot prop.
Please come.
Reading it verbatim for Your Lordship's convenience. On November 12, 2025, OGR issued a classification order declaring Astra Play to be a game of chance. The order relied on internal assessment suggesting that probabilistic variables embedded in the game's battle stimulation engine exerted a significant influence on outcomes, particularly during short-term matches, Your Lordship. So this
See,
is...
I have a problem, and I've always had a problem with this word called probabilistic variables. Because the word probability itself includes the word possibility. It includes and excludes at the same time, this word, correct? So if you have a word which is including and excluding, so you are putting everything within the realm of speculation. Once you put it within the realm of speculation, then they have to have an opportunity.
Your Lordship,
A small clarification.
certainly, Your Lordship. Also reading paragraph...
I'm with Honorable Justice. If there was some probability, at least a show cause notice should have been issued.
Your Lordship, when... To answer Your Lordship's
And
question...
if the Act does not provide for an opportunity of hearing, then the Act must, at least that provision of the Act, must be struck down.
Your Lordship, OGRA had a reason, they did give a reason that the presence of randomized reading paragraph 19, first line, Your Lordships. Randomized in-game events diluted the predominance of skill and rendered the game susceptible to chance-driven outcomes, Your Lordship. They were...
Yeah, right, we agree with you. We agree with you that it affects the rights of minors. We agree with you they exploit minors. We agree with you it's a chance, not only a game of chance, it's an addictive game of chance. Which somehow,
Correct, that will not come.
yeah, from day before his ruling in California on Meta and that damages which they've been asked to pay, that's what it is. Not protecting. So you are right, but you have to give an opportunity. That's the question.
Certainly, Your Lordship. However, there are exceptions to odi alteram partem, Your Lordships. The Council would like to refer a case law, Your Lordships. In Union of India versus Tulsiram Patel, Your Lordships, the facts was there was a dismissal of fair hearing. This was a similar case, the odi alteram partem part, Your Lordship. The ratio was that the hearing can be excluded in public interest and emergency, Your Lordship. In this case, we have seen that there is a data breach of 3 lakh users, Your Lordship. This data was financial, personal in nature, and this also surfaced on dark web forums, Your Lordship. And the data which was breached, it also included data of the minors. Now, the main aim of the act...
This closure order is on the basis of the classification or on the basis of the data breach?
Your Lordship, the game is, first of all, it is based on chance.
Please answer my query.
Both, Your Lordships.
Both. Have you given in your order that the closure order is on the basis of both the reasons?
Your Lordship, it was classified as a game of chance, and as well, it was classified as a game of chance by the audit. And there was further data breach also involved in the same.
That's a good answer. It is both actually.
Your Lordship, so there was the game, first of all, it was a game of chance. Further on, they did not comply with the regulations. There was a data breach because of them, Your Lordship. So the main aim of our act is to protect the consumers. Now the data breach has happened and our main aim is to protect the consumers. And now the consumers, their data is on dark web forums, Your Lordships. So we had to take, this was an emergency. Now because of this, they were denied fair hearing, and Your Lordship,
You're right, they were denied fair hearing.
Your Lordship, they were given the chance to appeal. Their
1 minute.
chance to appeal is not denied,
What
Your
normally
Lordship.
happens is, it says, show cause why your site should not be shut down. Show cause. And it can be done, if all material is available with you, it can be done within 24 hours, the hearing. It's only that you'll have clever lawyers who will say, we want more time.
Certainly, Your Lordship. However, the harm which
But
is...
then that's the lawyer's job, isn't it, to protect his client? So can you as a government stop this from happening, that no show cause notice, no reply, nothing, and off with the neck?
Your Lordship, the harm was of such grievous nature that the country or the state had to act.
Who decided it? OGA decided it.
Your Lordship,
And you have not set out any parameters for OGA also.
Your Lordship, the harm itself is so... The main aim is to protect the consumers.
Do you have a trained quasi-judicial officer sitting there, or is it a bureaucrat sitting there?
Your Lordship, the people who sit in OGRA has not been specified in the Moot prop, Your Lordship.
Okay, sorry, my fault. I shouldn't have asked.
Certainly not, Your
Carry on,
Lordship.
we give you some more time. Go on.
Much obliged, Your Lordship. Moving on with the contention regarding Article 21, Your Lordships, it is most respectfully submitted that online gaming regulation fully complies with Article 21 of the Constitution, Your Lordship. The restrictions are imposed through a procedure established by law. OGRA is enacted through a parliamentary process, and this particular act also satisfies the constitutionality test of proportionality. Petitioners are contending that the ban is not proportional in nature. However, the response... however, the respondents would like to say that... sorry, Your Lordship.
Carry on.
Certainly, Your Lordship.
One more minute we'll give you.
The respondents would like to say that they passed the reasonable test of proportionality, which was set down in Modern Dental College, Your Lordship.
You could have very easily said, if Your Lordship is insisting on a fair hearing, then give me some more time.
We'll give you a hearing, yeah, come on.
Come on.
Certainly, Your
Take your time,
Lordship.
take your time. Chalo.
Moving on, so the test of proportionality has 4 limbs. Firstly, there should be a legitimate aim. Here, there is an undeniable legitimate aim, your lordship, that cannot be contended upon. Secondly, there should be a rational connection. The council has established that there is a direct and a rational connection of the statute. Thirdly, there should be necessity. Here, your lordship, the OGRA does not prohibit gaming in entirety. It just specifically targets real money gaming, which it has identified as a high risk category, which is written in paragraph 12 of the Moot Prop, your lordship, and again paragraph 19 of the Moot Prop, your lordships. They have still allowed non-monetized gaming. They have still allowed chance-based esports, which do not have any monetary risk, your lordships. So the restrictions are narrowly tailored to address the segment associated with the harms only, your lordships, not in general banning any game, your lordship. Finally, there is balancing. Here, one side is commercial interest of the game Astra Play, and other side there is protection of public health. There is safeguarding minors and preventing financial exploitations, your lordship, which is paragraph 24 of the Moot Prop, your lordships. So because of that, there is a clear balance that the statute does not extinguish the gaming industry, but it merely regulates the high risk sector of the games, your lordship. If your lordships are convinced with the arguments, the council would quickly move to issue number 2, your lordships. Right. Much obliged, your lordships.
30 seconds, yeah.
Issue number 2 is online gaming falls within the parliamentary's residuary list, which residuary list of legislative power, your lordships. In Article 246, subclause 1, which is flag 14 of the compendium, your lordships, there is legislative authority upon the parliament to enact laws on any of the residuary list, your lordships. Here in this case, online gaming, as it is a modern digital phenomena operating within the internet-based ecosystem, is not explicitly mentioned in any of the list. Hence, it falls within the residuary list. And if there are discrepancies between the laws made by state and discrepancy in the laws made by union, then the union law would prevail, your lordship. This is again in one of the doctrines of occupied field, your lordship.
There's a question I asked them also, asking you also. If two state governments enact the same law, what will happen then?
Your lordship, however, in this case, this has happened, your lordship. Two states, different states have fragmented laws. This again proves why union has to come up and make the law, your lordships. Because in the Moot Prop, it is further written, your lordships, that there was the laws which were made by the state were fragmented in nature. They could not agree upon how they wanted to deal with this matter. So because of this, again and again, legal scholars and another ministry of the parliament had requested the union to come up. I would also cite the paragraph for your lordship's convenience. Paragraph 6 of the Moot Prop, your lordship. The council would read it verbatim for the convenience. Parliamentary standing committees on IT, technology and finance, along with expert task force constituted by the Ministry of Digital Affairs, repeatedly understood the need for unified national framework to regulate online gaming, your lordship. So there was again, paragraph 4 also states that prior to, first line, your lordship, prior to 2025, the regulation of online gaming in Indiana remained fragmented. So the states could not handle the issue. They were pretty fragmented. That's why union had to come in the picture and make a law which was unified, your lordship. So in pith and substance, the power falls with the parliament. Again, the states...
But gambling is a state subject, isn't it?
Your lordship, here the pith and substance does not fall within gambling, your lordship.
Gambling is a state subject. So now you're encroached.
Because of that, that's what she says.
Your lordship, OGRA is not regulating betting or gambling per se, but rather establishing a comprehensive regulatory framework governing online gaming platforms, your lordship. The name of the game, Online Gaming Regulation Act, also further proves that the...
But if it is not a game of skill, then it becomes a part of gambling. That is why you prohibit it. You prohibit it because it is gambling and not a game of skill. So therefore, you tend to encroach upon the field reserved for the state government. That's the point.
Your lordship, any overlap with entry 34 is merely incidental in nature, your lordship. Further, online gaming is a digital activity which falls within the parliament's residuary list.
So then the state can also do an incidental encroachment upon list.
Your lordship, if there are laws which are made on the same subject matter both by state and union, then the union's law is subject.
So incidental, you talked about something new theory, incidental encroachment. So if it's can the state also incidentally encroach upon?
Your Lordship, if there are laws which are made by union and state both, if they are incidentally encroaching upon a subject matter of union, Your Lordship, the law which is made by union will prevail, because if there are discrepancies between state and union, it is a set principle that the law made by union will prevail. Even if the state tries to incidentally encroach upon union's matter, union's law will prevail, Your Lordship.
But gambling is not union matter, na?
Your Lordship, in pith and substance.
Okay.
All right.
Thank you.
Finish.
Thank you.
Last sentence.
Certainly, Your Lordship. The Council would just quickly summarize issue.
One question to ask. In para 6 you just read that you underscore the need for a unified national framework to regulate online gaming.
Certainly, Your
Did
Lordship.
you consult the states before you came out with this legislation?
Your Lordship, paragraph 4 mentions that while certain states permitted real money gaming platforms, some prohibited it. So here the state itself cannot, two states are not agreeing upon the same matter, Your Lordship.
Did you consult the states?
Your Lordship, the Moot prop is silent upon that issue. However,
You can give some answer.
Your Lordship, certainly. Certainly, Your Lordship.
Give some answer.
Certainly, Your Lordship.
Say
Union.
yes, we consulted.
No, you can't say
Prove
that.
your point. Don't restrict to the yes. We have some innovation.
Your Lordship, the Council would not like to misguide the court by saying yes when not mentioned in the Moot prop.
Okay, thank you.
Best way to do it is may have consulted. Okay?
I don't
Or-
have, I don't
Correct,
have
I think
instructions.
that's
I'll
right.
seek
That's a-
instructions.
May have consulted or should have.
Or-
If not, I'll get back to your lordship.
Certainly,
explain.
Your Lordship. Oh, thank you for that point, Your
And
Lordship.
you know, today
Always
there's not going
say
to be
that.
any adjournment.
So that's the way a lawyer does it when he does not know the answer.
They would
to
have.
this.
They would have.
Certainly, Your Lordship.
They normally do. That's better.
Then the judge would say, please,
No.
please bring that would have to us.
They normally do. That's okay.
That's the way. How
Okay,
you-
certainly,
how to
Your Lordship.
deflect a court's question.
The Council would keep that in mind whenever next time the Council argues. Just moving on with the conclusions, Your Lordship. In the lights of the above statement, it is most respectfully.
Don't go into that. It's all right. Thank you very much. Let's get
It
to
was
the
an
next.
honor arguing before this bench, Your Lordship.
Thank you.
Thank you very much.
The Council seeks permission to approach the dais.
Yes.
Please.
Much obliged, Your Lordship. If the council is sufficiently audible, the council seeks permission to proceed with the further contentions. Much obliged, Your Lordships. The council will be taking 20 minutes of the court time in presenting issue number 3, 4 and 5 contentions. But before moving forth with the contentions, the council seeks permission to the court to rebut on a few points made out by the petitioner so that as to serve a clarifying purpose, Your Lordship. Much obliged, Your Lordship. Your Lordship, since the petitioners have failed to contend the point of 72 hours ban as mentioned in para number 19 of the Moot proposition, hence they agree that they are a game of chance, which serves as a argument from the issue number 1 and 2 for my co-counsel's convenience. Your Lordship, for issue number... Sorry, Your Lordship. Apologies, Your Lordship. For issue number 3, the classification is provided in para number 18. As my co-counsel has already pointed out that the audit mechanism and the classification orders have been pointed out in para number 18. Moving forth, in para number, the council seeks the bench's humble attention to para number 16 of the Moot proposition, wherein it is explicitly mentioned that Galaxy Gaming had voluntarily adopted responsible gaming measures. Your Lordship, responsible gaming measures are not equivalent to reasonable security practices as mentioned in the IT Act and the DPDP framework. Furthermore, Your Lordships, the encryption standards that the petitioners have claimed to abide by under section 8 subclause 5 of the DPDP Act are also not mentioned in the Moot proposition and serve as a misguiding principle to the court. Furthermore, Your Lordship, in para number 23, since the petitioners have denied all liability of the breach and denied that the breach has occurred, Your Lordship, in para number 23, page number 4 of the Moot proposition, in the last 2 lines, it is mentioned that Galaxy Gaming denied liability, contending that the breach resulted, wherein agreeing that the breach had occurred. However, it may have occurred due to a sophisticated external attack. Furthermore, Your Lordship, the reasonable gaming measures as mentioned in the Moot para 16 are the ones between user and the game, not the methods to which the game will prevent the following breach. Furthermore, your lordship, Astra Play is a fantasy game which makes it a game of chance based on its probabilistic outcomes as mentioned in para number 12 of the Moot proposition. If your lordships are convinced with the contentions, the council seeks permission to proceed with submissions of issue 3. Much obliged, your lordship. Issue 3 deals with whether Galaxy Gaming incurs liability under the Information Technology Act, referred to as the IT Act hereinafter, or the Personal Data Protection Act, referred to as the DPDP Act hereinafter. Your lordships, section 43A of the Information Technology Act imposes a clear and mandatory obligation on every body corporate that handles sensitive personal data. Your lordship, as mentioned on flag number 17, page number 240 and 241 of the compendium, it is mentioned in explanation 1 to section 43A that Galaxy Gaming falls squarely within the definition of body corporate, as it includes companies engaged in commercial or professional activities. Furthermore, your lordship, Galaxy Gaming is a commercial digital gaming platform engaged in systematic data collection and monetization of it. Furthermore, your lordship, section 43A of the IT Act provides that where negligence in implementing reasonable security practices causes wrongful loss, which in the given scenario has been crossed to 3 lakh users, explicitly minors, your lordship. Furthermore, the body corporate shall be held liable to pay compensation. The similar argument can be strengthened by using the SPDI rules, specifically the rule number 8, which mandates the implementation of reasonable security practices and procedures. Furthermore, your lordships, the petitioners attract liability under section 43A, B and J for unauthorized access, downloading, extraction and disruption or alteration of data from a computer resource. The compromised infrastructure under Galaxy's, the compromised infrastructure given in the Moot proposition, para number 21, wherein it is para number 22, wherein it is explicitly stated in the first line itself, your lordships, if the council could read it out verbatim for your convenience. Much obliged, your lordship, that the vulnerability in Astra Play's cloud-based analytics dashboard enabled the unauthorized third-party access. So, though your lordships, the Galaxy Gaming did not take utmost standards, let alone reasonable security standards to avoid the vulnerability and the breach. Furthermore, your lordships, the contention can be strengthened by using the constitutional position laid down in Justice K.S. Puttaswamy versus Union of India, which is given on flag number 6, page number 102, paragraph 4 of the compendium. Your lordship, wherein the informational privacy was recognized as a fundamental right under Article 21. Once privacy is constitutionally protected, statutory obligations protecting personal data must be interpreted strictly. If your lordships are convinced with the first limb of my argument, the council seeks permission to proceed with the second limb. Much obliged, your lordships. The second limb of my argument is that Galaxy Gaming is in fact liable for the unauthorized disclosure and misuse of data. As the council... Certainly.
What is the source of your information that there has been data breach of 3 lakh?
Certainly, your lordship, the Moot proposition para number 21, if the council could read it verbatim. On para number 21, the last 2 lines, wherein it is mentioned that the Astra Play's personal and financial information data of 3 lakh users was allegedly surfaced on dark web forums.
Allegedly?
Certainly, your lordship.
Who alleged it?
Your lordship, the OGA, the preliminary investigations conducted by the OGRA have alleged it.
So it's not final as yet.
Your lordship, that is what your lordship, that is what the...
When you use the word alleged, it means it's not final.
Your lordship, that is what the council is trying to contend in the given scenario, that the allegations are in fact true, that the breach has occurred. And the breach has occurred due to the vulnerability in their cloud infrastructure, your lordship. In citing the para number 23...
What is the source of what OGA is also alleged?
Certainly.
What is the source of information with OGA there has been a breach?
Has
the company accepted?
Your lordship, the company has denied all obligations as they would in arguendo. Your lordship, however, the denial of the breach itself is misplaced.
How does OGA come to conclusions like this?
Your lordship, by the audit classifications as mentioned in para number 17, 18 and 19 of the Moot proposition, as my co-counsel has already justified.
And the same question will rise, did you share them with Is all those with them?
Your Lordship, they were given a right to appeal. However,
Before this ban,
certainly,
ban is a 3-lettered word.
Your Lordship,
With
the
very serious consequences.
certainly, Your Lordship, the Council would like to draw the bench's humble attention to para number 23 of the Moot proposition, wherein they have accepted the breach but denied the liability.
Yeah, because see, obviously, breach has taken place. There's no doubt.
Certainly.
About it. But the question is, were they negligent? Did they not put in place those? I don't know what they are called. I'm
Reasonable
sorry,
security
I'm
measures.
a little digitally challenged, so I don't know those fancy words which are used. Did they put in all those in place so as to ensure that?
Certainly
data is
not,
protected?
Your Lordship. Certainly not. Your Lordship, as the Council has already justified
Where have
in
you said so?
Moot proposition para number 16, Your Lordship, on page number 3.
We've been 16, 17, 18, 19, 20, we've read till 23.
Certainly. However, the Council would like to contend that the measures that Galaxy Gaming had voluntarily adopted were between the user and the database. However, these are not the measures under reasonable security measures as mentioned in rule number 8 of the
In
statutes.
16 and 17, you set out the parameters which they were required to meet and which help you to collect all the information. But which ones were violated is not written anywhere.
The Council would like to clarify that in para number 16, it is justified that Galaxy Gaming had adopted responsible gaming measures.
But which one was violated?
Your Lordship, the breach itself is proof that the data encryption methods were not in place.
See,
Will you say that in a cyber attack, that
Certainly.
your point is that it was a sophisticated external cyber attack? That the standards that are adopted by normal entities
were not
of,
adopted.
are not sufficient? How do you, when in cyber attack, it tries to, try to breach every kind of firewall that has been put in place. So would you say that they did not take sufficient reasonable standards of?
Where are you saying that?
Certainly, Your Lordship.
And which is the standard they violated?
Where is it?
The breach itself is proof that they have violated the standards. The data
The
encryption.
breach is proof of the fact
Breach is
that
by
there
cyber
was a
attack.
breach.
Certainly.
That's all.
Breach is by a cyber attack.
However, it is due to the vulnerability in Astra Play's cloud-based infrastructure, Your Lordships.
Absolutely right. Absolutely right. But you've got to take it to there that they could have had a better system. This is what they should have installed. This is
Certainly.
what we have prescribed. They did not do that.
Certainly, Your Lordship.
You can't say that, no? You
The-
can't.
No, intention of the Union of India is to have ease of doing business, rather than to close the business, to ban them, give them 72 hours, shut down your business.
However, if the business is attracting or affecting 3 lakh users' personal, private and behavioral monitoring data,
Okay.
Your Lordship, it becomes a...
In addition to banning them, have you taken any other action also?
Your Lordship, the 72-hour...
Any criminal prosecution against them?
Certainly, Your Lordship. That is what the Council is trying to contend by using the IT Act 72A sections and 43A, B and J sections wherein...
Since there are minors involved, won't some other act also be involved?
Certainly, Your Lordship,
Which is that?
DPDP Act will be...
Something else also. Won't POXO come in?
Your Lordship, in the given scenario, POXO was not a part of our jurisdiction.
You think
It
it
is
would
to be taken by another board in
Who
itself.
Who told you that? A complaint of a commission of offence can be made by any person. The
Certainly.
Act says any person.
Certainly, Your Lordship. However, the Moot proposition did not allegedly ask us to look into the POXO Act in itself.
Okay, take it beyond the Moot proposition.
Certainly, Your Lordship.
Probably you could say that there is nothing which can attract POXO. Has there anything come to light which can
Certainly, Your
attract POXO?
Lordship. There was no sexual content which was introduced. It was allegedly surfaced on dark web forums. However, the personal information that was breached was behavioral, financial and personal in nature, not
You should-
sexual in
you
nature,
should
Your
take
Lordship.
this logic.
Certainly, Your
I'm
Lordship.
guiding you.
That is what
Much
we are trying
obliged.
to make you move forward.
Much obliged, Your Lordship. If the bench is satisfied with the first limb of my argument, the Council seeks permission to proceed with the second limb. Much obliged, Your Lordship. The fact that the intrusion may have been carried out by third parties does not absolve Galaxy Gaming in itself. The statutory scheme places liability on an entity, which is the body corporate, controlling the computer resource to secure it. The vulnerability in itself is proof that there were no encryption standards, no reasonable security standards in place, hence attracting liability under the IT Act framework. If the bench is satisfied with the second limb of my argument, the council seeks permission to proceed with the third limb. Much obliged, Your Lordship. The third limb of my argument is that Galaxy's non-compliance attracts liability under the DPDP Act 2023. Your Lordship, if the bench could kindly refer to flag number 19 from page number 250 to 255, which is the DPDP Act, Your Lordship, wherein section 4 mandates lawful processing only for permitted purposes. In the given scenario, the purposes permitted was to only identify or track the gaming behavior, not behavioral, financial or personal data, Your Lordship. The section 5 requires notice specifying the nature and purpose of processing. Your Lordship, in the given scenario, the notice was not explicitly provided, and the section 6 mandates free, informed, specific and unambiguous consent. Your Lordship, as the learned counsel from the side of petitioners have failed to establish how the consent in the given scenario was taken, the respondents have presumed that consent was not taken through the KYC methods as established in the Play Games 24/7, the Madras High Court judgment, that consent must be taken through KYC Aadhaar based models for minors, especially in online real money gamings. Your Lordship, so the consent.
You are relying on a judgment, you have come out with a new legislation. Why don't you make it a part of the judgment? Only the KYC is to be done like this. Why are you relying on the judgment of Madras High Court?
Your Lordship, the given judgment that I have relied upon are supposed to be taken into consideration while drafting a game.
In 2025, you have come out with a new legislation.
Certainly.
Why don't you provide in the new legislation all the KYC norms and SOP with respect to KYC?
Your Lordship, the same has been provided while taking into consideration the consent under the DPDP framework.
Then you say this particular section has been violated. Why do you talk about violation of Madras High Court judgment?
Certainly, Your Lordship, that was just serving as a supportive principle to the argument of consent in section 6, Your Lordship. If the bench is convinced, the council seeks permission to proceed with further contentions.
The data protection that you were saying?
Your Lordship, it is in the compendium, not the memorandum. Compendium flag number 19 from page number 250 to 255, Your Lordship.
Correct. Which provision of this are you citing which helps you?
Section 6, section 5, section 8 and section 13.
The DP Act.
Yeah,
Certainly, Your Lordship.
it is here. They gave a compendium.
As a bench officer, the compendium should have been available to all the.
They didn't give
The
the
council seeks permission to proceed further.
But doesn't this have a provision about identity of minors and all?
In this, doesn't the Act have the Digital Protection Act, Data Protection Act, doesn't it have a consent of minors provision here?
Certainly, it does. Your Lordship,
Where is that?
section 6, Your Lordship, on page number 251.
Yes.
So what is the extent of
Read
that?
it, read it.
Your Lordship, it is mandating free, informed, specific and unambiguous consent. In the given scenario, since the petitioners have failed to establish how the consent was taken, the
Does it have any provision regarding
The age.
data collected from minors? Because most of the people who are involved in gaming,
Certainly.
majority are minors today.
Minors.
Your Lordship,
In
the
fact, there's a separate segment of gaming from 10 to 12, 12 to 15, 15 to 18. There are separate types of
certainly.
games.
In case of a minor,
So
the
what is
parent,
that? Can you just tell us?
certainly, in case of a minor, the parent has to step in to provide the consent. As mentioned, sorry, Your Lordship.
Consent for data sharing.
Certainly. Your Lordship, furthermore, the statutory, there are substantive statutory obligations and they do not depend entirely. The reliance of the petitioners upon DPTP rules does not immediately devoid them of the entire liability under the parent legislation, that is the DPDP Act itself. Your Lordship, furthermore, the Galaxy Gaming, when it failed to prevent the breach in itself, violated not only statutory safeguards but also the underlying expectation of constitution of dignity and autonomy under Article 21. Therefore, the cumulative operation of sections under the cumulative operations of section 4, 5, 6 and 8 of the DPD Act, read with the IT Act provisions and the constitutional principles, Galaxy Gaming incurs liability. Further, if the
So far there have been allegations only from your side against Galaxy. What you are saying that everything is, so that everything stands true.
Your Lordship, the company was supposed to have reasonable security measures in practice, which is which when the breach occurred was violated.
It is an allegation.
Your Lordship, the breach is in itself a proof that the violation has occurred. The violation is further strengthened to the sections 43 and 72A of the IT Act, which attracts liability for the breach and vulnerability in the systems. Much obliged, Your Lordship. If the bench is satisfied with the arguments on issue 3, the council seeks permission. Much obliged, Your Lordship. The fourth issue deals with whether Galaxy's collection and use of minors' data violates the Digital Personal Data Protection Act and the constitutional privacy standards. Your Lordship, the section 9 clause 1 of the DPDP Act clearly mandates processing of personal data of child requires verifiable consent of parent or lawful guardian.
Where have you said that they did not take it?
Your Lordship, since the petitioners have failed to establish that there was consent taken.
This is great. This is like Kafka,
What is the facts?
great novel, The Trial.
What is the facts of your?
Your Lordship, when read with section 5 together along with section 9, it becomes evident that the child data cannot be processed through self-declaration mechanisms as mentioned in the Moot proposition or frictionless click-through systems. The petitioners have failed to establish how the.
How did you come to know that there were in the 300,000 or whatever, there were many minors data that was available?
Your Lordship, the enrollment of minors in itself is proof that the consent at inception was void.
How would you know that? How's the enrollment? You mean say, is there an enrollment process? Where do you get that?
Your Lordship, relying yet again on the Madras High Court judgment that the validity of the consent happens.
Come to the facts.
Come to the facts, first from the facts.
Certainly, Your Lordship.
That's my question. Where is the question that minors were being enrolled or minors, the data, firstly, how did you arrive at that there was minors data in that 300,000?
Certainly.
First question. Because the minor has to, I don't know if there's an age gating, whatever that is. Secondly, the
Parents notice to parents. That it was done, collected without notice to parents.
The council would like to argue the bench's answer the bench's question in a twofold manner. The first fold being referring to the Moot proposition. Your Lordship, in para number 21, in the last line, it is mentioned that in the last line, it is mentioned that approximately 3 lakh users' data was allegedly surfaced on dark web forums. Sorry, Your Lordship. On dark web forums, including minors, Your Lordship. The fact mentioned in the proposition is in fact the argument, contention that minors were entering the game in the first place, making the consent void at inception, Your Lordship.
It's not void. Come to page 258 of your compendium.
Your Lordship.
You don't have your compendium? 258. No, they'll answer it there. Na?
there were only one competitor.
Apologies, Your Lordship.
You have a digital copy of the same.
Your Lordship, are not allowed to use electrical appliances during the.
The digital copy. You gave the compendium, na?
Certainly.
Just see that.
Or you should have given us the digital.
How is it to be taken?
Your Lordship, these are the COPPA provisions.
This is applicable.
Certainly, Your Lordship, they serve as a guiding
Just
principle.
see this.
The council shall like to.
If they have to share anybody's data or anything, they have to take the permission from the parent.
Parent.
Just read that.
Which is also, certainly, Your Lordship, which is also provided under the section 9 clause
Please don't
1.
keep on saying certainly again and again. Come to the point. Sorry, this may sound a little rude, but
Certainly.
haven't you charged them for
The
this?
bench said lead it.
Your Lordship,
Read
they
it
can.
loudly.
Read it out, read it out.
The content of direct notice to parent for purposes of obtaining consent, the direct notice to obtain parents' affirmative consent to the collection, use or disclosure of child's personal information.
This can't be more serious.
The council has not relied entirely upon this upon the given statute, because the given statute serves as a guiding principle in the Indian law system, Your Lordship. The council has relied upon section 9 subclause 1 of the DPDP Act, which also requires,
Read that.
certainly, Your Lordship. Thank you.
Is there
Your
any
Lordship?
allegation of sexually explicit content?
Certainly not.
No.
No, Your Lordship. The section 9(1) reads out verbatim that the data fiduciary shall, before processing any personal data of a child, obtain verifiable consent of the parent or lawful guardian of such child in manner as may be processed. The respondents have relied upon the same to argue the fact that the minors were entering the system without the verifiable consent, hence their data was breached. If Your Lordship is convinced with the...
I have a basic question to you.
Certainly.
Whether this gaming legislation allows participation of children?
Your Lordship, it provides that minors can enter the gaming rooms and gaming platforms, however, with the consent of parents.
How does a minor, can you explain, since you people are now experts in gaming, you're the government, how does a minor make payment?
Your Lordship, the same has to be verified by the parent as well,
How does the minor make payment?
which has to be based on the parent's account itself, Your Lordship. It cannot be based on the minor's account.
Don't you think it should be banned completely, minor playing a game with money of the parents?
Your Lordship, even if the union puts a ban on the games, the minors will still enroll. It is the responsibility of the gaming federations or the companies to ensure that even if minors are enrolling, there are no vulnerabilities that might cause the data breach.
Gaming federation.
Gaming companies, Your Lordship.
But you see, the gaming companies are there to make profit.
Certainly.
So why would
However, profit must not be made at the risk of 3 lakh users, Your Lordship.
Then you ban the minors with money. You allow minors without money.
Your Lordship,
She's not the policy maker.
Right now, but right now she is rapidly using.
however, the council would like to contend that relying on the Madras High Court judgment of the KYC verification method, the KYC verification has to be done.
I'm not on KYC at all.
Is
Certainly.
there a fundamental
No,
judgment
but
which
what
says
she's saying is
gaming is
that
bad?
the KYC
not bad?
method ensures that the minor cannot log in or he cannot use it.
But with the consent of parent can.
Parent.
Certainly.
With the consent of parent can.
Yeah.
Yeah, with the consent of the parent, he has to take his parent's card.
Yeah, card, that's the problem.
He has
is
to
not the
take his
card.
parent's card.
Because nowadays the minor, they force the parent to use their card.
If the bench is satisfied with the council's contentions on issue number 4, the council seeks permission to proceed further with...
2 minutes, extra week.
Much obliged, Your Lordship. The issue number 5 deals with whether the creator access framework is an exclusionary and anti-competitive arrangement under the Competition Act 2002. Your Lordship, the petitioners argue that the framework, creator access framework, chills innovation and fails the test of proportionality. Your Lordship, dominance carries a special responsibility under section 4 of the Competition Act, which is mentioned on flag number 22, page number 286 of the compendium, wherein abuse includes imposition of unfair or discriminatory practices. Your Lordship, the 2-year restriction limits the creator's ability to experiment across platforms. It discourages innovation and reduces the inter-platform competition. To support the argument, the creator access framework also fails the test of the principle of proportionality as recognized in Om Kumar versus Union of India, wherein flagged on flag number 8, page number 155 of the compendium.
That's with you only.
No, Your Lordship, the compendium has been returned.
Yeah.
It's okay, it's okay.
Are you competition lawyer?
So So we're giving
The-
you how much time left?
1 minute more, 1 minute.
The judgment requires that the restrictions must be suitable, necessary and balanced. Even if the protection of IP is a legitimate objective, the blanket 2-year exclusivity term is not the least restrictive means, Your Lordship. To draw a parallel or an example, the petitioners could have used a 6-month term. Since they had a 1.8 million users boom within 6 months, it is enough time for the company to have a secure system or to avoid their IP using under the 6 months term itself, Your Lordship. Comparative jurisprudence also supports this approach, that in Microsoft versus the European Commission, tying an exclusionary conduct by a dominant digital firm was scrutinized, Your Lordship. In Epic Games versus Apple, the platform controlled the digital markets and our restrictive ecosystem practices were examined for the competitive harms. Galaxy's creator access framework risks the given structural harm, and therefore under sections 3 subclause 4 and section 19 subclause 4, the creator access framework causes appreciable adverse.
Said or your colleague said that there are not only Galaxy, there are many other players in the market.
Certainly.
How do you prove this dominance by Galaxy?
Your Lordship, to prove dominance, the Council would like to point out the section number 19 subclause 4 of the Competition Act, which lays down factors such as market share, size and resources, economic power, dependence of consumers, entry barriers and network effects. Your Lordship, the focus is on the term network effects in the given scenario. Network effects refer to... Much obliged, Your Lordship. Network effects in the given scenario refer to the...
There's a question.
Certainly.
They have pleaded that their market share is something less than 1%.
Your Lordship, what they have mentioned is not the market share, however the market size, as in 0.04%. The market share in the given scenario is not provided. However, the dependence of consumers is provided, which is 1.8 million users, which gives leads to the argument of network effects, which is that network effects, as mentioned on flag number 10, page 201, para 90 of the compendium, Your Lordship, occurs when the value of product or services increases and more people use it. It determines the market boundary and how the dominant market is established. The relevant...
The dominance depends on so many things.
Certainly.
See that explanation of section 4 that talks about the dominance. How they cover under dominance, whether they can influence the pricing of their competitor, whether they can give the pricing of their own, how they can do that. With this minor, even in whatever you are saying, I think that when market share is nothing, then how they can be a dominant?
The market.
Your Lordship, the market share is not mentioned in the Moot proposition itself. So, assuming the market share would mean... Certainly not, Your Lordship. They have misguided the bench by saying that 0.04% is the market share. It is the market size which is given in the given scenario. Your Lordship, to answer the bench's question, the Council would like to contend the relevant market point, Your Lordship. The relevant market...
How is it doing? How is the Galaxy, its creator access framework constitute anti-competitive behavior? How do you arrive at that?
Your Lordship,
What are the restrictive terms?
Your Lordship, the restrictive term mentioned in the creator access framework was that the independent gaming deployers cannot deploy similar modules for 2 years exclusive term.
How do they prevent that from happening?
Your Lordship, by protecting their IP is what they have mentioned by as a defense, that they will be protecting their IP and investment in the given scenario. However, Your Lordship, having proven that they are a dominant player in the market using their network effects, relying on the principle of proportionality as mentioned in Om Kumar versus the Union of India, it is mentioned that Galaxy Gaming is a dominant player and the creator access framework fails the test of proportionality. Hence, it has appreciable adverse effects on competition, Your Lordship. If the bench is satisfied with the Council's contentions on issue number 5, the Council seeks permission to recite the prayer. Much obliged.
You don't have to put all your hand on that, we don't do all that. That's
happen?
not done in any court.
Why is this? I would like to ask.
This is not like Mussolini's, you know.
But why you have been?
Who has advised you to put your hand like this?
Our college authorities.
No, that's not correct.
All colleges are doing this.
All colleges are doing that.
Certainly.
Hmm?
It's a gesture of respect towards the court, as we have been taught.
No, I think there is some rules that have been issued to all moot by
Moot court,
moot
is that
committees
how
and
it
all
is
that.
distributed?
Something like this.
Is that,
So why don't
why
we use
you,
Hitler's salute then?
you can do that also. Anyway, that's not required. I don't think it happens in courts. So
No.
why would you do it in a moot court?
Nobody.
Indeed, Your Honor. Wherefore, in the light of facts presented, arguments advanced, authorities cited, and issues raised, the counsel on behalf of respondents humbly prays before this honorable court to declare that OGRA is a constitutionally valid exercise and holds legal competence to pass any order, and declare that it is not violative of Article 14, 19(1)(g) and Article 21 of the Indian Constitution, to declare that Galaxy Gaming is liable under the provisions of DPDP Act and IT Act, and to declare that the creator access framework of the Galaxy Gaming is inherently causing appreciable adverse effects on competition and is an exploitative term in agreement, and or pass any order that the court may deem fit in the light of justice, equity, good conscience and fairness. For this act of kindness of your highness, of your lordship, the counsel on behalf of respondents shall duty bound forever pray.
Thank you very much.
It was an honor arguing before this bench.
The honor is always of the bench, listening to lawyers.
I tell you on the lighter side,
Don't give them. That's done.
There has to be a rebuttal, right?
You want a rebuttal? No, I don't think they are happy.
no, they are very happy after listening to our questions. They are really they're feeling very comfortable now.
No, but what is the system here?
No,
How does it
there's no rebuttal.
As per the rules, like rebuttal.
There's no rebuttal.
Rebuttal, Your Honours, is discretion of the court. So,
Whenever we are addressing you, just to stand up first.
sorry, Your Honours. Your Honours, it is the discretion of the court of regarding rebuttals.
So how is the choice of the appellant and the respondent made in this? What is the mechanism by which you get
Draws of lot, Your
draw of
Honours.
lots?
Then they keep changing sides.
That's gaming, right?
Without money.
So you may get the better proposition. Anyway, I think thank
I
you.
think let's rise.
We'll rise. Thank you.
Thank you very much.
Thank you.
Oh, sheets.
We'll do it there.
We'll do it there and then. I haven't asked me why should I?
Yeah, we'll have
We do it, yes. Later first result, sir. First result. Result is more important. Just carry result sheet.
Good afternoon, everyone. Esteemed guests, respected members of the judiciary and the bar, our Honorable Vice Chancellor, faculty members, and dear students. It is my privilege to welcome you all to the valedictory ceremony of the second SRMUH Moot Court Competition 2026, organized by the Faculty of Law, SRM University, Delhi NCR, Sonipat. Over the past few weeks, this competition has truly reflected the spirit of legal advocacy. The preliminary rounds were conducted online, allowing teams from across institutions to participate, and over the last 2 days, we have witnessed the advanced rounds here on campus, where participants presented thoughtful arguments, demonstrated strong research, and engaged in rigorous legal debate. Moot courts are not merely competitions, they are classrooms for advocacy where future lawyers learn the art of persuasion, discipline of research, and the responsibility that come with the practice of law. Before we formally begin the valedictory ceremony, it is our tradition to seek the blessings from the goddess of knowledge and wisdom. In the Indian academic tradition, Saraswati Vandana symbolizes our respect for learning and intellectual pursuit. It reminds us that knowledge grows best when guided by humility and wisdom. May I request everyone to kindly settle down as we begin the ceremony with Saraswati Vandana. I would request the IT team to please present the Saraswati Vandana. Thank you, IT team, for that beautiful invocation. It now gives me great pleasure to call upon Professor Dr. Vijay Kumar Singh, Dean, Faculty of Law, SRM University, Sonipat. Professor Singh is an experienced academic and administrator whose work spans academia, regulatory institutions, and policy think tanks. Under his leadership, the Faculty of Law continues to... So, please.
A very good morning. Honorable Mr. Justice Rajiv Bhalla, former Judge, Punjab and Haryana High Court, Shri Ashok Kumar, Honorable Vice Chancellor, Sports University of Haryana, Dr. Vijay Kumar Agarwal, Senior Consultant, Head, Competition Law and Policy at Lex Indus Law Offices, Mr. G.P. Madan, Managing Partner, Madan Law Offices, Dr. G.V. Rao, Senior Advocate, Supreme Court of India. First of all, I would like to thank you all for sparing your valuable time for judging the moot court, and I'm sure it was a great display by the teams who have come from different parts of the country. It gives me an immense pleasure to welcome you all to this valedictory session, which is culminating actually after a 1-month marathon. So we had this Moot in a hybrid mode. So we have 32 teams participated and in the preliminary rounds, which was held in the first week of March. And from those 32 teams, we could get the 8 teams who have been doing the qualifying rounds in the quarterfinals, which we called in the campus. And here they fought yesterday for their quarterfinals and semifinals. And today you witnessed the finals and judged that. So it gives me an immense pleasure to actually announce that this is a great success for us. This is the second edition of the Moot which we are holding at the Faculty of Law. Faculty of Law got conceptualized in the year 2013, and since then we have been working on different programs. There is a 5-year program which we run, that is on BA LLB and BBA LLB. We have a 3-year LLB program as well as LLM and also PhD. So all these students, including our first-year students, got enriched by this whole moot court exercise, because this gave them an opportunity not only to participate, but also to organize. This organizational skills, you can see all these students. Can we have a round of applause for all my students, because these are the people who were behind that, and they have done a great job. The moot problem was a unique problem. It was on the e-gaming and sports, which is a new area, emerging area. A lot of contemporary issues are coming around that, including competition, IP, and I'm sure the teams would have dwelled hard on that and bringing up their arguments. So this was a unique area. We initially drafted the problem, got it vetted by PLR Chambers, which happens to be one of the law firms, and they vetted it, and then finally we could release that particular problem. And in the final rounds, you have seen the teams coming. My convener of the moot court, Dr. Shubham, will be giving you a detailed report about the moot. I again welcome you all for this function, and thanks a lot. Over to you for the proceedings further. Thank you.
Thank you very much, sir, for those encouraging words. Every successful academic event is the result of dedication, teamwork, and careful planning. Much of the credit for organizing this competition goes to the Moot Court Committee and its faculty leadership. It is now my pleasure to invite Dr. Shubham Singh Bangla, faculty convener of the Moot Court Committee, to present the moot report of the second SRMUH Moot Court competition.
Thank you so much, Yoshika ma'am. Honorable Mr. Justice Rajiv Bhalla, former judge of the Punjab and Haryana High Court. Dr. Vijay Kumar Agarwal, senior consultant and head of the competition law and policy at Lex Indus Law Office. Mr. G.P. Madan, managing partner at Madan Law Office. Shri Ashok Kumar, honorable vice chancellor of the Sport University of Haryana. And Dr. G.V. Rao, senior advocate at the Honorable Supreme Court of India. Honorable Vice Chancellors, esteemed dignitaries, distinguished judges, respected faculty members, and dear participants, a very warm and gracious welcome to this august gathering. It is a both privilege and indeed a profound honor to stand before you today and present the report of the second SRMUH Moot Court Competition 2026. An esteemed flagship initiative of the Moot Court Committee, Faculty of Law, SRM University, Delhi NCR, Sonipat. Building upon the resounding success of its inaugural edition last year, which received widespread recognition and acclaim across academic and professional circles, this year's edition of the competition has been envisioned on an even grander and more rigorous scale, further strengthening its legacy of excellence and institutional prestige. This prestigious competition stands as a testament to our institution's steadfast commitment to fostering legal excellence, cultivating advocacy skills, and advancing meaningful engagement with contemporary legal discourse. The competition was meticulously conceptualized to provide aspiring legal professionals with a rigorous and intellectually stimulating platform that enables them to refine their research aptitude, analytical reasoning, and forensic advocacy. The moot proposition in particular was thoughtfully curated to engage participants with complex and evolving legal issues situated at the confluence of the recently enacted the Promotion and Regulation of Online Gaming Act 2025, constitutional law, cyber law, data protection law, intellectual property rights, competition law, and artificial intelligence domain that are rapidly redefining the contours of modern jurisprudence. We were privileged to organize this competition in collaboration with SCC Online as a knowledge partner and SCC Times as the exclusive media partner, thereby significantly enhancing its academic gravitas and national outreach. The preliminary rounds were conducted in a virtual format on the 6th and 7th of March 2026, facilitating broad-based participation from institutions across the country. Subsequently, the advanced round comprising of the quarterfinals, semi-finals, and the grand finale are being conducted in an offline format here at the campus of SRM University, Delhi NCR, Sonipat. The competition witnessed an overwhelming participation of 32 teams representing premier national law universities, central universities, state universities, and leading private law schools, thereby transforming this event into a vibrant confluence of legal intellect, strategic thoughts, and persuasive advocacy. The inaugural ceremony held on 6th of March 2026 was graced by eminent legal luminaries, including Professor Dr. R. Venkata Rao, Honorable Vice Chancellor of the India International University of Legal Education and Research, Euler, Goa. The insignificant deliberations and inspiring address delivered on the occasion set a distinguished and intellectually enriching tone for the competition. We remain deeply indebted to our esteemed university leadership, Honorable Vice Chancellor, Professor Dr. Paramjit Singh Jaswal, and respected Registrar, Sir, Professor Dr. V. Samuel Raj, for their unwavering support and visionary guidance and constant encouragement in strengthening the mooting culture at our institution. As the competition progressed into its advanced stage, the quarter-finals round witnessed exemplary display of legal acumen, strategic clarity, and redefined courtroom advocacy. Following a rigorous and closely contested knockout rounds, the competition advanced to the semi-finals with the top 4 teams that are being SN8 Institute of Law, Nirma University, SN5 JSS Law College, Mysore, SN6 Army Institute of Law, Mohali, and SN2 Symbiosis Law School, Pune. These rounds were marked by exceptional clarity of thoughts, doctrinal depth, and commendable advocacy. After an intense and intellectually charged semi-final rounds, the 2 teams that have distinguished themselves and advanced to the grand finale are SN6 Army Institute of Law, Mohali, and SN8 Institute of Law, Nirma University, Gujarat. One of the most defining hallmarks of this competition has undoubtedly been the distinguished panel of over 50 judges whose extradition, experience, and discerning evaluation have been instrumental in upholding the highest standard of legal adjudication. The panel comprised eminent academicians, seasoned practitioners, policy experts, and advocates on record, each contributing invaluable perspective to the proceedings. We are also privileged to host partners and professionals from reputed organizations and leading law firms, including Knowledge Consultant, Tata Steel Limited, Fox and Mandal, Cyril Amarchand Mangaldas, Trilegal, Anupam Sanghi and Associate, HSA Associate, LLO Legal Advisory LLP, Rizwan Law Associates, R.K. Diwan and Company, and Govilkar Associates, whose presence added significant professional depth and industry insight to the competition. Further, enriching the intellectual fabric of the event, legal officers from eminent ministry, including Ministry of Law and Justice, also graced the competition as judges, bringing with them invaluable institutional perspective and practical expertise. We are further deeply privileged that the final rounds and the valedictory ceremony is being graced by an exceptionally distinguished panel of dignitaries. We are honored to have with us Honorable Mr. Justice Rajiv Bhalla, former judge of the Punjab and Haryana High Court, Dr. Vijay Agarwal, senior consultant and head of the competition law and policy at Lex Indus Law Office, Shri G.P. Madan, managing partner at Madan Law Office, Shri Ashok Kumarji, Honorable Vice Chancellor of the Sport University of Haryana, and Dr. G.V. Rao, Senior Advocate at the Honorable Supreme Court of India. Their esteemed presence lent immense prestige to this occasion and served as a profound source of inspiration for all present here. As we now stand at the threshold of the final rounds and the valedictory ceremony, it is important to recognize that this competition transcends the confines of a mere contest. It represents a journey of intellectual enrichment, professional discipline, and experiential learning. Each participant has demonstrated remarkable perseverance, dedication, and a commendable pursuit of excellence. On behalf of the Faculty of Law, SRM University, Delhi NCR, Sonipat, I extend my heartfelt gratitude to all the dignitaries, judges, faculty members, organizing committee members, and participants whose collective efforts have culminated in the resounding success of this competition. As we prepare to witness the grand finale, let us bear in mind that mooting is not merely about winning, it is about mastering the art of persuasion, engaging with complex legal questions, and upholding the enduring ideal of justice. I extend my very best to the both finalist team. May their advocacy exemplify the finest tradition of legal profession. Thank you. Over to you.
Thank you so much, sir. We are now privileged to hear from our guest of honor, Dr. G.V. Rao, Senior Advocate at the Supreme Court of India. Dr. Rao is a renowned legal professional with more than 3 decades of experience in constitutional law, international law, and complex litigation. He served as the Vice President of Indian Society of International Law and has previously chaired the National Council of Arbitration and Mediation as ASSOCHAM. His expertise spans constitutional law, international and domestic arbitration, corporate disputes, and civil and criminal litigation. Alongside his practice, he has also contributed to the legal education as the visiting faculty at leading institutions and has actively mentored young legal professionals. Sir, it is a privilege to have you with us today. May I please invite you to address the gathering?
Thank you, everyone here. It's been a pleasure this morning. It's been a pleasure to sit with Justice Bhalla and my friend G.P. Madan, who was my classmate. Vijay, of course, we've been working together in so many things at the Indian Society of International Law, etc. Firstly, let me tell you that it was a very, very high quality moot. I was impressed by the problem itself. It is very current, very topical. It dealt with competition law, it dealt with the Digital Protection Act, it dealt with issues that are really the topmost and whichever future that is that we're talking about in complex technology and corporate area in this field. So that was the moot problem itself, very well set, and I was impressed by the way it was done for youngsters. I think it's exceptionally well thought and also very well participated, and the competition was very high between both the teams. They did a great job in working on the problem. Both the teams, I would say, knew almost everything that was connected with the problem. Their memorials were very good. They had done great research in the case law. The question that I put towards the end is, how did you get to be the appellant or the respondent? And they told me it is by draw of lots. So many times what happens is the moot is, proposition itself is loaded in favor or against of, so one team will have a slight edge because the proposition is tilted towards them or it's in favor. So therefore, I don't think the team which won, or the team that did not make it should feel bad. They did a great job as well. But sometimes it's good luck and good fortune that helps, and that you must know. I'm very glad that you did all of that, and we are very happy to be here. I wish you all good luck in future and being great professionals in the court. Thank you for inviting us. Thank you very much indeed.
Thank you, sir, for your valuable insights. It is now my pleasure to invite our next guest of honor, Mr. G.P. Madan, Managing Partner at Madan Law Offices. Mr. Madan brings over 3 decades of experience in corporate legal advisory, corporate governance, capital markets, and insolvency practice. He currently serves as the chairman of the NCLT and IPC Committee of PhD CCI, co-chair of ASSOCHAM M&A Task Force, and Joint Secretary General of the NCLT Bar Association. A fellow company secretary and insolvency professional, he has addressed more than 500 conferences and professional forums across the country on subjects such as company law, corporate governance, insolvency, and board practices. So we are honored by your presence. May I please invite you to address the gathering.
Thank you. Good afternoon, everyone. First of all, my thanks to Dr. Vijay and Dr. Paramjeet for inviting me here, and so that I could interact with Honorable Justice Bhalla, my other co-panelists, including Dr. G.V. Rao, and all the faculty members and my dear students. I have a passion of interacting with the students. And that is where the moment Dr. Vijay, once he told me, that, can you come on this date? I tell you, it was very difficult for me, but when it was interacting with the students, I couldn't say no, and particularly Dr. Vijay, I cannot say no to him. Friends, I echo the sentiments of Dr. G.V. Rao with respect to the problem. I tell you the problem with respect to this problem, the live issue, pending matter is sub judice. It was an opportunity for me also to go through the particular legislation, to go through the research done by you. It was really handy for me. And tomorrow if somebody asks me to speak on this subject, I'll be the first one to speak on this subject. Thanks to all of you. And coming to this courtroom, before this valedictory session, it was a courtroom, you know, daily basis pe to we are sitting there only. Matter चल रहा है तो ठीक है और नहीं आ रहा तो कभी कभी sleepy भी हो जाते हैं, नींद भी आ जाती है, vibration mode में या silent mode में चले जाते हैं. But when you're sitting on this chair, even Honorable Justice Bhalla was also telling me it's very difficult to write judgments. Not only writing the judgment, even listening to the counsels also is not an easy task. You can't miss even a single submission of the counsels. Am I right, sir? You have experience throughout your life. It is very difficult. It's not possible to miss a submission. I mean, you have to be very, very alert, very, very vigilant while these counsels are submitting their submissions. So it was a great opportunity for me. And my best wishes not only to the winning team, but all those teams who have participated in this tournament or in this event throughout, from the preliminary round to the final round. I mean, winning is not the ultimate thing. Participation is the best thing. And participating and then speaking before the court, I tell you, shuru mein अच्छे वकील ना कांपने लगते हैं. And it's a great opportunity for all of you that you are getting this opportunity to take part in the moot court competition, to do your research, to give your submissions, standing before the court, arguing for 20 long minutes is not an easy job. And then also countering the questions which are coming from the judges. Hats off to you. And all those who have not participated so far, my humble guidance to you to please do participate. Please do prepare for the next sessions. Maybe in this university or in the other universities also you will be getting a lot of invites. Do participate in those, and I wish you all a great, bright future career, a professional career and a personal life. Thank you.
Thank you, sir. It is now my pleasure to invite our next guest of honor, Shri Ashok Kumar, retired IPS and current Vice Chancellor of the Sports University of Haryana at Rai, Sonipat. Shri Ashok Kumar served with distinction in the Indian Police Service for over 3 decades, culminating his exemplary law enforcement career as the 11th DGP of Uttarakhand in 2023. He is widely respected for his administrative acumen, his authored works on internal security and policing, and his lifelong dedication to the intersection of sports and education. Sir, we are honored by your presence. May I please respectfully invite you to address the gathering.
Thanks a lot, Dr. Jaswal and Dr. Vijay Kumar for inviting me. Because for me it was first experience. Though I've been Vice Chancellor of NLU Sonipat also for 3 months, but there we didn't have this exercise. Maybe they have not yet started it. So it was quite an experience for me. And the quality of the debate, of the presentation was very high. And I could relate because it's a relevant topic to police and it's criminal law also to some extent. So online gaming, it's been a long debate, is a crime or not. We've been doing it all through. Even for cricket, you know, that becomes a big issue. Betting, whether it's a crime or not. Many people still maintain it is not a crime, but we keep arresting also. So it's a big topic. But I would just say that congratulations to the whole team and the participants, and I would say that quality was excellent. My best wishes. Thank you.
Thank you so much, sir. It is now my privilege to invite our chief guest, Honorable Mr. Justice Rajiv Bhalla, former judge of Punjab and Haryana High Court. Justice Bhalla served with distinction as a judge of Punjab and Haryana High Court from 2004 to 2016, contributing significantly to the development of jurisprudence during his tenure on the bench. After his successful judicial career, he continues to contribute to the legal profession as an advocate of the Supreme Court of India. He is widely respected for his expertise in land and property laws and remains actively engaged in legal discussions, lectures, and academic interactions that contribute to the development of legal scholarship and practice. Your Lordship, it is an honor for us to have you with us today. May I please respectfully invite you to address the gathering.
Thank you and good afternoon to everybody. And to all those on the dais who were members of the bench, and to Professor Paramjeet Singh and the faculty, as well as all the youngsters sitting in the audience. Thank you for bearing with us. Most of us are above 50 or above 60, and most people above 50 or 60 will only keep on advising you, okay, do this, do that, and nothing more. They do not tell you any practical stuff. But yes, I would have to admit that when I came here, I did read this proposition. I have no idea absolutely about it. So that's the role of a judge. He sits as a judge, he has no idea about the case, and then he gives you a judgment. But fortunately, we don't have to give a judgment here. That's the best part of a moot. And thank you to everybody for being here. But what I've got to say, we had 4 girls today, and that just shows
6.
that
No, 3 and 3, yeah. 6.
4 girls who spoke,
two researchers.
2 who were the researchers and who were passing on the parchis. If you ever come to the Supreme Court and once you become a senior advocate, you also have 2 people standing on your either side, one speaking in your left ear and one speaking in your right ear. So once I was arguing a matter, and one was telling me one and the other one. So I told the judge, just a minute, let me first sort them out. And I don't know what they're telling me, so let me first sort them out. So this parchi business sometimes ends up confusing the speaker. You got to be sure what you're saying. I've seen this happening in almost all moods. The person sitting down below keeps on sending small missives to them that say this and say that. But this proposition was a little confusing, maybe because I had no knowledge about it, no idea about it. But at the same time, hats off to the youngsters who managed to crack this and come out with such wonderful presentation and then speak and then withstand our repeated questions, some of them good, some of them bad, some of them indifferent, and some of them maybe even silly. You might have thought, how can they do it? But that's what judges are. Judges will ask you every question, even the silliest possible question, you have to reply. And you can't tell the judge, oh, your question is silly. You have to say, Your Lordship is absolutely right, but I have my different opinion. And then you have to continue. So that's the way. Now the problem with this profession, which is growing, and I'm seeing it every day, I see it not only because I'm as a lawyer, I've seen it as a judge also, is the total lack of practical knowledge when you come into the profession. The day you come into the profession, you get the shock of your life, is this the profession I was preparing for? You have no idea where you're coming in. And unfortunately, the Bar Council prescribes the syllabi, and though Bar Council is run by lawyers, but somehow they seem to forget that when they joined the profession, they also had no knowledge about the profession. There's no practical, except for these moots. And then in these moots, like you had this, somebody putting the hand here, which we pointed out is not something which happens in moots. I don't know, probably some protocols are prescribed for moots, and maybe that is the reason why it is. But I am framing a little course with one of the universities in Punjab, which is called Practical Legal Education. And we'll be offering that to all universities, and where I've got a group of lawyers from the Supreme Court, from High Courts, from trial courts, who will be explaining to children what is actual practically, what's going to happen to you in court. I mean, don't be frightened, nothing very frightening happens. But at the same time, it's serious work. You see, what happens in today's times in the law is that it's like the doctor operating on the patient, and then they say, okay, fine, don't worry, he died, I got my fees, so what? So that's what's happening to youngsters. Then the youngsters don't know even how to start, what to do, how to talk to a client, how to work in an office. You go and work in an office, absolutely, I have at any given time about 5 interns in my office. Lots of universities, youngsters coming to me. They have no idea what's a plaint. They have no idea what's a written statement. Here, sitting with me are probably corporate people. They also don't know what's a plaint. Just pulling your leg. Because they deal with large litigation. But what happens is, we all tend to forget that 90% of this country is at the trial court level, at the magisterial level. We talk about competition commissions, we talk about NCLT, NCLAT, everybody wants to be a corporate lawyer, but exactly who's going to serve those 90%? Who's going to be prepared for them? So my small request to everybody is, do not don't see the success of these gentlemen over here, because they have done their job, they are doing their corporate work. But 90% of your litigation is at the trial court level. Learn that matter. That's where most of you will go there. So my small request to all of you is, take these moots seriously, take your classes seriously, and do not hesitate to ask questions from your teachers. The problem is, none of you ask questions. I myself have been taking classes in colleges after demitting offices, but when I ask a question, there's always a deathly silence. So small request to all of you, please continue to work hard, and I'm really surprised at the level of the 2 teams we had. They were brilliant, and that's the only word I can say. Thank you very much for having all of us over here, and best of luck. We don't know who's won actually. We've given marks separately, so all the best to everybody. Thank you very much.
Thank you, Your Lordship, for that thoughtful and inspiring address. Now I would request our esteemed guests to please come forward for the distribution of prizes. So please.
Yes, sir. All the corporates in front.
So here. Yes. Yes. So I'll call them. Let us congratulate the participants who have shown remarkable dedication, preparation, and advocacy during the quarter-final rounds. We heartily appreciate the team dedication. First in the line, we have SN7 Campus Law Center, Faculty of Law, University of Delhi. Please come forward. The team comprising of Tanveer, Jessina, and Harsh. Okay, moving forward, SN4 Rajiv Gandhi National University of Law, Patiala, Punjab. Yug Raman Srivastav, Jennifer, and Pranav. Let's have a huge round of applause for our quarter-finalists. Let us have a huge round of applause again. Clap should not be stopping. Next in the line, we have the Best Researcher Award. I would request V.K. Agrawal sir to please present the Best Researcher Award. Any guesses, teams? At least the team buddies can cheer them up. Any guesses for Best Researcher? SN3, Mohan Babu P. Tamil Nadu, Dr. Ambedkar Law University, School of Excellence in Law, Chennai. Team comprising of Mohan, Mukelan, along with the cash prize of 11,000 rupees. Let's have a huge round of applause. Next, we have Best Speaker, SN3 JSS Law College, Autonomous, Kuvepuram Nagar, Mysore. Amog, team comprising of Amog, Ajanya, and Astha, along with the cash prize of 11,000 rupees, SN5. Let's keep the claps going on. Let's have a huge round of applause for our winners. Next, we have Best Memorial. Best Memorial Team Award goes to SN1, Delhi Global Institute of Management, Faridabad, along with the cash prize of 11,000 rupees, team comprising of Richa, Trisha, and Palak. Let's not let the sounds, let's not let the whole be silent. Congratulations to the team. Let's have a huge round of applause. Next, we have second runners-up, that is SN2 Symbiosis Law School, Pune. Team comprising of Sudhi, Akansha, and Divyanka, along with the cash prize of 21,000 rupees. Let's have a huge round of applause for them. Let's cheer them up and congratulate our winners. Let's not the hall go silent. Now I would like to hand over the floor to our esteemed guest for the announcement of results for winners and runners-up.
Where are the 6 girls?
Both the teams, please come forward.
Come here.
SN6 and SN8, please come forward. Army Institute of Law, Mohali, and Institute of Law, Nirma University.
So before
से.
See, they've rightly put you behind the bar. So you have to be lawyers in future, so you're behind the bar. This is the place between the judges. And do you, any of you understand what's the meaning of the bar? No, because in England in olden times, they had a bar between the bench. Actually, a bar between the bench and the lawyers. This is starting from the 15th century. So that's what the bar is.
That's like the bar.
So you're right behind the bar now. So the idea of getting all 6 of you here was so that since you're all winners, but then unfortunately it's called the tyranny of numbers. So somehow we have to choose somebody or the other. So the runner-up is Army Institute of Law.
Runner-up
We'll give runner-up first.
last. The runner-up is
The winner comes automatically, na? So I don't know. There are 2 institutes. There are 2 institutes. So which one do you guys think are the winners? The people at the back.
At least cheer, guys.
Who do you
The
think
team
will win?
buddy should cheer for the team.
Okay, the winner is Institute of Law, Nirma University.
यहीं पे.
And the runner-up, obviously, you guessed it, is Army Institute of Law. So,
No, it is the winners. They are the winners.
Sir, say low, na?
Let's not the hall go silent. Keeps on clapping, guys. Let's congratulate and appreciate the efforts of the team. SN6, Army Institute of Law, Mohali, team comprising of Pallavi, Anjali and Sukhman Preet. Along with the cash prize of 31,000 rupees. 51,000 rupees. एक सेकंड, ये रनर अप बोलकर मैंने विनर को ट्रॉफी दे दी. The runners-up, SN6, Army Institute of Law, Mohali, team comprising of Pallavi, Anjali and Sukhman Preet. Along with the cash prize of 31,000 rupees. Let's have a huge round of applause. I would request all the winners to come forward for a group photograph after this. All the winners, best researcher, best speaker. Outside?
Requested to please come outside in the veranda for the photograph along with the faculty members. Along with your trophy. And prizes. Okay?
So we shall proceed after this. बोलूं मैं क्या बोलूं? Sir, can we have the photograph after the close of the ceremony? Okay, sir. Thank you, everybody. Let's move forward for a group photograph. Everybody, please cheer up and come outside.